So, hello everyone, welcome to the licensing hearing on the 13th of November. The first item on the agenda is for the subcommittee to elect a chair, and understand that they've elected Councillor Rose, is that correct? So I pass over to Councillor Rose to chair the meeting.
Thank you very much. Good morning, everyone. Thank you for joining us. Please note that this meeting is being live webcast, and a recording of this hearing will be also made available to view on the Council's website. Going straight into item 2, apologies for absence. Are there any apologies for absence today? No, we've got a couple of slight tweaks to representatives. We'll get to that. Item 3, I will go around the table and introduce everyone so that it's clear who is participating today. I'm Councillor Jason Rose, and Councillors Anne Hook and Michael Nichols and I are the members of the hearing panel subcommittee. We're joined by Council Officers Matthew Boxall as Head of Public Protection, Rhys Williams as Democracy Officer, and Jodie Ingram as our lawyer. The applicant is Little J Limited, represented by Leo Charlambides, the responsible authorities are the police, represented by Paul Clark, and the licensing authority and public protection, represented by Sandra Brannigan. We also have 5 representatives, namely Jake Furby of York LGBT Forum, who isn't present and has been replaced by Joe McKenzie and Phil Grossett, Wayne Dawson of Queer Arts CIC, Dr. Andrew Malcolm Neal, Debbie Saunders on behalf of Generate, who has to leave halfway through and will be superseded by Big B Eris Waterson, and Jake Cragg. Is everyone satisfied that nobody's been missed? Have I mispronounced anyone's names? Yes, go ahead, sorry.
Yeah, okay, Leo to read my speech.
Yes, not a problem. Everyone else happy with everything that I've just said? Haven't missed anybody out? Okay, sorry, yes. Craggs. Thank you. I will update my lists. Fab, that's item 3 on the first page of a very long order of events. Item 4, declarations of interest. Are there any declarations of interest for this meeting? No. Item 5, exclusion of press and public. As always, I formally move the motion to resolve to exclude press and public during the subcommittee's deliberations and decision-making at the end of the hearing, on the grounds that the public interest in excluding the public outweighs the public interest in that part of the meeting taking place in public under Regulation 14 of the Licensing Act 2003, Hearings Regulations 2005. Are we happy with that? Great. Item 6, we were going to discuss approval of the minutes of 26th of June, 28th of August, 8th of September, and 29th of September, but I'm aware there are minor amends and formatting changes, so these will go to the next hearing. And with that, on to the substantive item 7, the determination of the application. Before we get into it, I just want to preemptively address everyone present to make sure we're on the same page. This is a licensing hearing for a premises license within the cumulative impact area, and that is what will be determined today. This is an unusual application, both because it's a premises within the cumulative impact area seeking to go from no license to a 7 a.m. to 4:30 a.m. license, and because it is an application to be, as it stands, the city's only LGBTQIA+ late night community events venue. There are lots of complicated factors to this, and lots of opinions will be shared. Having read all of the papers, I can see there has been a lot of history and discussion and tension around this application. Hopefully today will be a grounded and positive meeting. I just want to make it crystal clear that the members of this panel are the decision makers, independent of council officers or the police, who will make an informed decision that is grounded in legislation and policy. There is no doubt of the merits of having safe venues for all people in the LGBTQIA+ community, and there is no doubt about the open hostility, including the many comments we see online and in the evidence for this application. All representatives can speak on numerous topics, but I would like to encourage people to focus on the specific tangible decision today, which is the consideration of whether the grant of a license will add to the cumulative impact and the likely effect of granting a license on the licensing objectives of the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. Because there are lots of representatives, I will be firm on timings. We will take breaks where appropriate. And I intend to try and keep us in line with the official procedure as much as possible. Hopefully everybody is happy with that. And with that in mind, I'll go through a summary of the procedure now. The licensing officer's report will be presented, and each party in turn will then have a maximum of 5 minutes to ask questions about the report. In each instance, here and after, the order of representations or questions goes applicant first, then police, then licensing authority, then public protection, and then the interested parties, and then at the end, the members of the subcommittee. After questions to the licensing officer, each party in turn will have a maximum of 15 minutes to make their representations, and after each representation, every other party can ask clarifying questions to the representative for up to 5 minutes. Then each party will have up to 5 minutes to sum up, in the same order except the applicant sums up last instead of first. Then members can ask any final clarifying questions of anybody in public before withdrawing for private session. Is everybody happy with that and understands that? Yes, Sam?
Chair, sorry, absolutely, except that slight tweak, if I may, to the running order. Could please public protection go before the licensing authority for reasons that I hope will become apparent.
Nobody objected to that, presumably? That's fine. I will have to make sure I don't forget that. But I will switch that around in my notes and hopefully get that right. But yes, that's not a problem. Any other issues with the running, or anybody want to validate or check anything that's not clear? Because I did talk quite a lot there. Okay, great. A few minor points. Is everyone happy with how to use their microphone? There's a button in the middle if you haven't used it before. Make sure that it's lit up. I'll shout if you're not unmuted. Has everyone seen all 5 agenda supplements? Yeah. We may make a decision quickly, and people are allowed to wait for an overview of our outcome if so, but the decision might not be made immediately. Whatever the timing on the decision will be notified in writing to all parties within 5 working days. And finally, if everyone takes the maximum time available, including the licensing officer, that's 10 hours without councillors speaking at all. So please stay concise where possible, try to avoid repeating things that have already been said, and we'll be as brief as we can in totality, however long that may be. All of that said, can we start with the licensing officer's report, please?
Yeah, thank you, Chair. So as you've said, this is an application for the grant of premise licence at Little J's, Chapel House on North Street. The licensable activities applied for are plays, films, indoor sporting events, live music, recorded music, and performance of dance, all indoors, 11 p.m. to 3 a.m. Sunday to Wednesday, and 11 p.m. 4 a.m. Thursday to Saturday. Other forms of entertainment indoors, 8 a.m. to 3 a.m. Sunday to Wednesday, and 8 a.m. through to 4 a.m. Thursday to Saturday. Supply of alcohol on and off the premises, 11 a.m. to 3 a.m. Sunday to Wednesday, and 11 a.m. to 4 a.m. Thursday to Saturday. This ought to take place within the opening hours of 7 a.m. to 3:30 Sunday to Wednesday, and 7 a.m. to 4:30 a.m. Thursday to Saturday. There are some non-standard timings for licensable activities on Christmas Eve, New Year's Eve, Halloween, Pride event, and bank holiday Sundays until 4 a.m. closing at 4:30 a.m. The premises is described in the application as a community events venue with licensed bar, a maximum internal capacity of 120, an independent venue run by and supported by local LGBTQI+ community to provide a dedicated safe space for the community to come together through music, arts and performance. A copy of the application and plan can be found at Annex 1. An overview of the circumstances in which entertainment activities are not licensable can be found at Annex 2. As part of the application, an operating schedule was submitted by the applicant and shows how the licensing objectives are proposed to be met, and this can be found on pages 45 to 48 of the report. As you said, the premises are located in the cumulative impact assessment area. The sections of the statement of licensing policy which deal with that can be found at Annex 3. Obviously, because of time, I won't go through this at length. Safe to say that at paragraph 9.11 on page 57, it states that the onus is on the applicant to demonstrate to the responsible authorities the suitability of how their proposal will not add to the cumulative impact. I can confirm that the consultation process was carried out correctly. North Yorkshire Police have made a representation based on all 4 licensing objectives. Their representation can be found at Annex 4. Environmental Protection have made a representation based on the prevention of public nuisance. Their representation can be found at Annex 5. The Licensing Authority have made a representation based on the prevention of crime and disorder and public nuisance. Their representation can be found at Annex 6. There have been 6 relevant representations from other persons. The details can be found at Annex 7, and they were accompanied by a petition of 1,636 names These representations are in support of the application and can be found at Annex 8. A map showing the general area around the premises can be found at Annex 9. The mandatory licensing conditions are at Annex 10. Legal and policy considerations at Annex 11 and the qualities impact assessment at Annex 12. The committee has the following options when making its decision. Option 1, grant the licence in the terms applied for. Option 2, grants the licence with modified additional conditions. Option 3, grant the licence to exclude any of the licensable activities to which the application relates and modify add conditions. Option 4, refuse to specify a person on the licence as a premises supervisor. Option 5, reject the application. Again, as you've just said, since the report was initially published, additional information has been received from the applicant, North Yorkshire Police and Environmental Protection, and these have been published as agenda supplements. That is my report.
Thank you very much. We will go through questions in order, as already said. So, Lee, on behalf of the applicant, you have 5 minutes. I am timing it.
I have no questions, thank you.
That was fast. I will reset the clock. Paul from the police.
No questions, Chair.
Okay. Public protection.
No questions, Chair.
Licensing
Thank you.
authority.
No questions, thank you.
Representatives in order. So we have LGBT Forum first.
No questions.
We have Wayne of Queer Arts CIC.
No question.
Andrew Malcolm Neal.
Also no questions.
Debbie Saunders.
No questions.
Jake Craggs.
No questions.
This is going to be faster than I thought it was going to be. Okay, 15 minutes then for the applicant. Thank you.
Sir, thank you very much, and thank you for your opening. I thought it was helpful. I only disagreed with you on one point when you said there was complicated factors in this application. It seems to me that this is a very straightforward application, albeit by parties that perhaps speak different languages. The only thing that I would add, of course, to your opening is your overriding duty under the Quality Act to engage in the public sector equality duty, which you three must deal with personally. You must grapple with it yourselves, and there's a lot of information there for you. So it seems to me, because I was really trying to cut through what is going on in this application. There's, I think it's fair to say that certainly high passions have been engaged. And I think to everyone's credit, from their own standpoint, everyone is indeed dedicated to what the process is about. And certainly on the part of Graham, I think what we have in Graham is someone who has come from a background who understands oppression, who understands prejudice, who understands discrimination, and who speaks the language of activism. The police, for example, speak the language of regulation and dry law. I get that. It makes a lot of sense. It's perhaps not very interesting, but the two languages don't fit very well together. It's very regrettable that the police here are now seeking to advance a case on personalities rather than principles. I'm not going to go into that particular gutter, and I'll leave it for them to do so. But for my part, I'm actually going to focus on regulation and the dry language of law. And in that case, I'm going to be really quite boring. So apologies in advance to that. So as you've rightly identified, what we need to do here is seek to promote the licensing objectives, which, whatever our policies might say, are the overriding consideration. That includes your cumulative impact policies. You, as a committee, are also bound to have regard to the Section 182 guidance, which you're no doubt familiar with. Paragraph 1.5 sets out key aims and purposes, which are vitally important and should be principal aims for everyone involved in licensing, which include encouraging greater community involvement in licensing decisions and giving local residents the say to have regards to licensing decisions that may affect them. Your regulatory framework ought to reflect the needs of local communities and empower local authorities to make and enforce decisions about the appropriate licensing strategies in the area. So a lazy read of your policy might be, cumulative impact policy, which sets an interesting bar. But when I was reading your statement of licence and policy, it struck me that where I could have been best guided, and I think where you can be best guided, is your policy also sets out other aims, which are just as valid as your cumulative impact policy. And these include, at paragraph 4.4, the vision that you have. So exactly those key aims, which at the fifth bullet point is having a safe city centre, which is welcoming and accessible to all. The current reality is, and I'm going to use the word queer, not that I'm missing out any of the alphabet in LGBTQIA. I just think it's a useful umbrella term. And I've been helped by the York's LGBT Forum little pamphlet, which I found in Little J today. And queer is the overarching term of preference. Queer people visiting York who want to come into your city centre late at night are clearly told, you're not welcome here. There is no dedicated space for you, which is the practical effect of commercial operations. Maybe they've come, they've gone, they've failed. Maybe your own cumulative impact policy, which acts as a barrier, and a very rigid legalistic approach to CIA. What we're really encouraging is for you to apply your vision in an appropriate and creative way. So the very basic question, which is not at all complicated as far as I'm concerned, is whether you and your colleagues, on behalf of City Council, want to have a varied and diverse licensing offering, which is also part of your policy. It makes it clear at paragraph 6.4 that the diversity of offering is a principal aim for you, whether you're going to follow those two aspects of your policy or not, and say to queer people in York or the surrounding area, welcome to York, you're welcome in our city centre, in our historic heartland, you're welcome in our entertainment district, and you're welcome to stay late at night. Or whether you're going to say, no, you're not welcome, or even worse, say, no, but you've got to be in bed by 11 or 12 or whatever it is, which is, well, I don't think I need to use the language of law, but it's very rude, isn't it? It's very patronising, and of course it's highly prejudicial, which offends your public sector equality duty, which you must give, in my submission, paramount consideration for. But let's turn to the safety aspects, and again, I say there's very little that stands between the parties. Firstly, you have an operating schedule, but I'll just turn to the police representations to begin with, because I mostly agree with them. So on page 90 of the agenda, the police set out 10 conditions. Condition 1 is agreed. It's a matter of semantics, but I would invite you to add community event, venue and bar. And not that it means anything. Condition 1 requires that the premises operates effectively as a queer venue. This is hardly revolutionary. You've seen it in the context of restaurants. Alcohol must be ancillary to food. In the context of cinemas, alcohol or theatres must be ancillary to the entertainment. So what you're doing, and we thank the police for agreeing with this, is safeguarding the venue as a genuine community space. So there is that. And I know there's been some discussion in the passionate email exchange, and those of you that have read that exchange, well done on your fortitude. Like I said, I didn't propose to go there. A drinking up time, no concern about that. When the venue is open and operating for licensable activities, a minimum of 2 SIA registered door staff shall be provided at the premises from 1900 hours. I'm just going to pause there a moment and just ask you to add for alcohol licensable activities. Now, alcohol is an important distinction. It impacts on the impact of the premises, but it also impacts on economic factors. When you're selling alcohol, you're making more money and you can support community events. When you're not selling alcohol, you can't. So it's a very useful distinction to have. So I would add the word alcohol there, because I think quite rightly, when alcohol is available on any venue, having a greater regard to security is far more useful. When it comes to the hours, the programme of proposed events is that certainly until 9, 10, 11 o'clock, it's likely that they will be community focused. It will be cabaret, it will be lectures, it will be open mic, it will be comedy and so on, which are of a lower impact, certainly of a lower capacity. Our experience with our temporary events notice is that we tend to peak between 70 to 80 persons. It's only been around Pride when we've had a kind of party vibe, when we've achieved our full capacity of 120. So finding some sort of economic balance and economic viability, which of course are not considerations for you, but they are the practical matters. I'd suggest that the time at which the SIA are bought in when there is alcohol for sale is from 2200 hours, and that achieves the balance, because one, it's likely that it will be a later event, and two, it's likely that it will be needed. And then, despite, I think we're nearly 180 pages of police evidence, we agree to everything else. So I hope that that's a useful indication. What I might add is we've given a restricted event plan, which is in your restricted papers, which demonstrates the real full range of activities for that. One of the reasons it's restricted is because we are concerned about the impacts. I think you've all seen the petition and the horrific responses that have been contained in them. So despite the openness of everyone in this room, the reality is not everyone is as enlightened. And what I propose is that we send a monthly calendar / risk assessment in advance to the police responsible authorities so that they can review it. And if they wish, they can give advice to the applicant on events that they might think are particularly difficult, as the case may be. In terms then of public protection, you'll see at page 97 onwards, the 97, 98, the conditions are agreed. You'll see there that there are 3 outstanding conditions which have been settled, it seems to me, by Dragonfly. I think it's the one of the most recent supplementals. There you'll see that taking an approach in combination with your licensing authority, with your sound and environmental health experts, we've come up with the conclusion that insofar as noise impacts is concerned, there will be no discernible impact. Well, effectively that puts that to bed. There is going to be no significant impact from this. So in respect of the outstanding conditions 1 and 3, they're entirely unnecessary and otiose. Using the methodology agreed with public protection, it's not needed. The testing has been done with open doors. And as a matter of fire safety, the front door must remain open because it opens out into the street and is also the fire exit for a neighbouring use. So that condition, if imposed, would actually create a fire risk. So you'll be sort of ticking the public nuisance box, but undermining the public safety box. But as it is, it's entirely not needed. Insofar as the licensing authority are concerned, they quite properly highlight your community of impact policy, which is here engaged. But this is a small and tested venue and has the unique hallmark of being proposed as a safe, queer venue for the city in its absence. And so, as you identified, there is no doubt that the city needs this. And so on that basis alone, in terms of you advancing equality, having a vision for your community, that is quite an exceptional factor which needs to be addressed. For such a major city not to have a queer venue must be terribly embarrassing for the local council. And so that in itself is activated. And when we think about your public sector equality duty, we've provided you with a great deal of information that you can rely upon and grapple with, which sets out the impacts of York not having a queer venue, not having a nightlife presence, and the impact that it has. You see through the images the very reactions that this application must cater to and answer. So this application, if granted, restores a sense of equality, restores a sense of confidence in the council, not to mention the police and other regulatory bodies, and provides a landmark for equalities, thank you very much, which can be properly advanced and meets the consideration for your policy. So to sum up in conclusion, I've tried not to get involved in the tittle tattle. I've focused on the conditions, how we propose to operate, the practical considerations of your public sector quality duty, and actually your policy aim of advancing equality, diversity, and having York be genuinely welcome to all, rather than the heteronormative majority that currently enjoy all the nightlife rights in York, as opposed to this community that enjoys none. So, sir, on the basis that we don't object to the applications, that we meet your policy exceptions, I would urge you to grant this application, which, the tittle tattle aside, is effectively agreed by all the parties. Thank you very much.
Thank you. 1 second over, we'll let that off.
Thank you.
Spot on. Right, straight into the questions for the applicant, starting with the police then, please.
No.
Okay, public protection,
No questions.
licensing
No
authority, representatives in turn, York LGBT Forum, Queer Arts CIC.
That's me. As much as I love my own voice,
You can
I'm
ask
not
yourself
going to
the
question
question.
myself.
I need to write that down so that I don't keep asking every single round. Andrew, what's the question? Debbie?
No questions.
And Jake. Okay, then we move on to 15 minutes for the police's case, please.
Thank you, Chair. This is an application for a vertical drinking establishment within the CIA. That's what it is. As has been mentioned, there is the community impact area policy that you have. 911 of that states onus is on the applicant to show how it will not add to the cumulative impact. Further, the council recommends early consultation with responsible authorities. And that is the real issue that we have here. There has been very little effort, if any at all, by the applicant to engage with the relevant authorities with this application. In fact, it's been even worse than that, where there have been inflammatory posts, there have been untruths posted and made by the applicant in respect of particularly the police's approach to this application. I note 2 of you were on the last hearing that was adjourned, and although we weren't allowed to make any representations, I did make committee aware that the applicant himself had posted that the hearing was adjourned even before committee had made any decision. And in respect of that, that demonstrates the unsuitability of this particular applicant regarding this application. 9.14 talks more favourably about our factors that could make an application more favourable. None of those appear in this application. When this first application came before the police, if it was simply that it was a vertical drinking establishment within the CIA, it would have been refused absolutely. That's the whole point. We considered this application in support of the LGBTQI plus community because we recognise the real concerns. We don't just look at the law in a dry way. We are the community. We are here to protect the community, and we take that seriously. So we gave serious consideration, and that's why you'll see the conditions that we were proposing. But over the months of this application, it's become more and more apparent that the applicant is wholly unsuitable to have such a venue. So in respect of Little J's itself and the community venue, that already exists. And so there is a venue where such activities can take place. I accept that's without a license, but with a license comes great responsibility, and any applicant has got to show that they're up to that responsibility. I note in the papers that the applicant has said, and everything has been at last minute, this application's been going on since August. The noise report, it appears, was started in September, and we saw it a couple of days ago, and I'm sure there'll be comments made in respect of that. In the application, it uses a comparator of another community, LGBTI plus community hub in the London area. That doesn't have a license. Looking at the licensing objectives, which are at the forefront of this application, because again, this is not the police trying to prejudice against the LGBTI plus community. We are responsible for the safety of the people of York. And if we don't think that a venue can be run safely and responsibly, it's our duty to act, even if that draws criticism from parts of the community. Protection of children from harm. In the application, there is no provision whatsoever for children not being on the premises. So you can have a child at any age on that premises to 4 o'clock in the morning. That certainly isn't promoting protection from children from harm. In the documents that we've read from the applicant regarding ID checks, he has, or there's been reluctance to impose any sort of challenge 25, which would ordinarily be agreed by any applicant on the basis that the LGBTQI plus community are wary of having ID because of the questions that it can have on their identity. We are sympathetic, of course. However, one of the licensing objectives is protecting children from harm. Children of all ages need to be protected, of all ethnic groups, part of whatever community they are, they need to be protected. Public safety. In respect of that, again on page 27 of the bundle that the applicant submitted, it says it's going to be a safe venue for the LGBTI community and patrons. So does that mean it's going to be unsafe for everybody else? That might sound trite. However, it does identify how, rather than having an holistic view of this application, it's been very much specific to the applicant and their views. The venue itself has not been risk assessed by the fire services as of yet. So the capacity is an issue. We don't know whether it's safe. We haven't been on the premises. When we did visit the premises, the police weren't invited onto the premises when they visited at Halloween, when they were checking a lot of different venues within the York area. And what we did see was an iron gate that was closed. That gives us great concern, because late at night or at any time, if you've got a venue where people are drinking, or there's a large number of people and there is a blocked exit, that is a disaster waiting to happen. Prevention of public nuisance. Of course, it's going to add to the public nuisance, because you're going to have more people within that area at very late hours at night and early hours in the morning. People aren't going to leave silently. If people leave by taxis, for example, it's going to increase the noise and the public nuisance. That is obvious. So there will be some impact there. Prevention of crime and disorder. You have the CIA, because unfortunately, York is the victim of its own success, where you get so many people visiting the area. And I suppose the old adage is, alcohol in, brains out, and people change their attitude. I've done much research over many years of the effects of alcohol on me, and I know how certain people it affects significantly, leading to an increase in crime and disorder. But in respect of that, one thing that we need that's crucial, and it shows by the number of venues that there are in York that we work with. It's very rare. This is the first time I've appeared before committee, notwithstanding the adjourned hearing. It shows how rare it is that the police object. And it's only when we've got real concerns that we do object. We need to know that we can trust the management of a venue to work with the police to deal with issues, because every venue will have issues, but it's about how that venue deals with those issues. And if we don't have any trust in them, and we don't, that means that we really do have concerns about the impact that venue will have on the community if it is not managed properly. So we say, Chair, first of all, in respect of the policy of the CIA, it falls foul of that. And secondly, in respect of the licensing objectives, we say that this venue, not because of the people who will be frequenting it and do frequent it, I know it's successful. I, over the duration of this case, have seen some of the comments that have been posted. And what I would say is, if anybody suffers, if anybody feels as though they're subject of harm, come and see the police. We have a range of civil orders that we can go to court, and we regularly do, that protects vulnerable people. And that's the main part of my job. So it falls foul of the licensing objectives and the current DPS, we as the police cannot trust because of his mendacious attitude towards the police over the duration of this application. That's our representations, Chair.
Thank you very much. And apologies to my colleagues who we skipped over in the questions for the applicant. I actually did have a bunch of questions. I just got caught up by nobody having any and moved on quickly, but we do get a chance to ask at the end. We'll go in order and I won't miss us out this time. Questions for the police, starting with the applicant, please. 5 minutes.
First question, have you provided an equality impact assessment or other documentary evidence to prove how you've grappled with your public sector equality duty in terms of your response to this application?
Chair, in relation to this, I liaise with our public sector equality duty officer within North Yorkshire Police regarding this, which is what our legal representative said, is that we have considered this application based on your policy at 6.4 diversity, because there is not an identified LGBTQI plus venue in York. And based on that, that is the reasons why we were open to considering this venue and wanted to engage with the applicant. It's the reason we put forward, as council has highlighted, the first condition, so that that would be protected in relation to those conditions that are offered. So that was done, and consultation with our legal was that the policy within North Yorkshire Police had been adhered to.
So you're saying that LGBTQIA venue in these circumstances is potentially an exception to policy?
That is absolutely correct. Thank you.
You described this venue as a vertical drinking establishment. Page 58 of the bundle. Sorry, page 58 of the bundle, you described the application as a vertical drinking venue. The venue is described at page 58 of the bundle. It's described as a community space for people to come together through music, arts and performance. That doesn't list vertical drinking, does it?
No, and just
No.
to reflect on that, the reason that the condition was written in the first place, that the LGBTQI plus community venue is there in condition, is that it can't be used for another function. So it protects that community to have its own venue. However, in the absence of any conditions offered by the applicant for any seating, any table covers, which we would have with restaurants and that kind of thing, then yes, vertical drinking is permitted. So though the venue may not have that as its primary function, without those conditions on there, it absolutely can operate as a vertical drinking establishment. And unless the applicant wishes to condition it to have seating or something similar written in, then yes, of course, it's a vertical drinking establishment. And that's the way we have to approach it, because there isn't anything there that prevents them from doing that. And that's the point. And just to reflect on the last point, in the why we've considered this, if a regular bar like any other in York were going to ask for a late night license, we ordinarily would not consider that, and we would look to object outright. So we haven't objected outright to this because we understand that need for diversity, but we do need to still make sure that the conditions are there, because we're talking about a license application, and we're not talking on the community aspect of it.
Yeah, that's helpful. So we agree, PSCD, EIA, we agree we're not a vertical drinking venue. Paragraph 8.46 of the Section 182 guidance makes it clear that applicants are not required to seek the views of the responsible authorities. I appreciate your miffed, which is probably an understatement, that you haven't had the engagement you like, but this isn't a relate hearing. There is no legal requirement on any applicant to consult you, is there?
No, but
No,
of course, the policy
that's
from
all.
the
Thank
council
you.
does say that on the CIA policy that the onus is on the applicant to.
I'll agree with you, it's a good idea.
Yeah, wonderful.
And in terms of children from harm, the operating schedule on page 76 that was with the application, it's quite wrong for your lawyer to say that protection of children from harm is not considered, because you see there entry restrictions, concerns for the under 18 and a proof of age policy, yes?
Sorry, just clarify what page you're reading from.
76, it's in the application.
Correct.
Yeah,
Yes.
and again, access and entry is considered at page 65 under films.
Well, of course, in relation to films, that's covered, yeah.
And I'll do everything else in my closing. Thank you very much. Thank you.
Thank you very much. Which way around are we doing? Public protection.
No questions.
And licensing.
No questions, thank you.
Representatives, York LGBT Forum.
Yes, just have a question for the police, please. You mentioned Halloween. I was actually running that night, so I was there. And if there is a question, I spoke to the two officers who came to the premises and had a very positive, very supportive conversation with them. They were absolutely lovely. They were at pains to say that they were there to support us, to look out for us if there's any trouble, to get in touch with them. I had probably a 5-minute conversation with them at the entrance to the venue. The gates you mentioned are given complete visibility to the venue. They can see everything that's happening. We had a great conversation and then they left. So they gave me no impression that they wanted to come inside because we had the conversation that we would have had inside. So did the officers themselves either express concerns that they weren't invited into the premises? And as a follow-on question, did they report any trouble, or have there been any reports from officers on the ground who have enjoyed great relationships with? Have there been any reports of trouble from any officers on the ground?
Just in response to that question, Chair, I watched the body-worn video footage of the officers attending, and it was I agree with you, it was very positive engagement. They felt that whilst they didn't openly ask outright to be invited into the venue, they felt that there wasn't that offer to go inside, and they didn't want to upset anyone by asking to then go in. They weren't sure about this gate, so they were unaware of that. They're just normal officers that patrol. They're not experienced licensing officers, so they were aware that the venue was obviously not licensed. They were wanting to engage to provide those reassurance patrols because, as we know, that night was a very busy night, particularly in the city, and they didn't want your community to feel that they weren't being engaged with by the police to provide that positive reassurance should there have been an incident take place.
Well, that sounds extremely respectful and considerate, and that was my impression too. And from watching the footage, that seems to be your impression as well.
Yeah, absolutely.
And so just confirm, there haven't been any reports of any incident from either?
Not that we are aware of, Chair.
Yeah, thank you.
No further questions there. Okay. I guess it's Leo again, but Wayne, queer arts, CIC, no. Andrew?
No question.
Debbie?
No questions.
Jake? And this time I am going to turn around and ask Michael if you've got any questions for the police.
There you go. Just go from it. In terms of the application, it's the applicant you have problems with. The application and accepting all your conditions. If the applicant name changed, would that make any difference?
The application itself is in the name of Little J, which is a company name. The concerns that have arisen in relation to the designated premises supervisor. We recognise the need, and I think we've acknowledged that in this hearing, that there is a need for that type of venue within the city. So the objections have arisen in relation to the designated premises supervisor.
Cool. And in terms of children, protection of children, have you any suggestions of what would make you happier about access for youngsters?
So I think, and as council have pointed out, there was obviously in the operating schedule, there was reference to children will not be permitted after 2200 hours in relation to events that are held. Just in relation to the submission from council regarding the change to the wording around where door supervisors would be put on if you are minded to look at a condition around alcohol. That was the concern where we came from in relation to the protection from children from harm, because obviously if there is alcohol events on and the concerns that we've had around the Challenge 25 condition, we need to ensure that we're going to have the correct staff checking the identity of persons entering the venue for any permitted films, etc., that are going to be shown. Whilst there may not be alcohol shown, we need to ensure that we've still got those protections of children from harm in relation to that.
Or indeed any other forms of entertainment that may not be suitable for young children. So that's why it's just important to make sure that those conditions regarding the Challenge 25 and the timings would be something that we would feel necessary on the application.
In terms of, obviously, there's been lots of events that are not alcohol related, community events. Has there been any concerns in when people have left those events?
So in relation to the venue itself, I can confirm that I've run a check on our systems, and we have had no reports regarding certainly the events that we were aware of, which I can only comment would have been notices, the temporary event notices. I wasn't aware prior to receiving the additional material yesterday of all the other events. So obviously I've looked at the date specific to when temporary event notice were on.
Thank you.
Let's I guess following up on that, in terms of the temporary event notices, were there any concerns in terms of those continuing being repeated future events?
So the first temporary event notice that we looked at was in relation to the Pride event, which took place back in June. Now, the Pride event itself in York goes through the Safety Advisory Group, and there was significant engagement from the licensing team in response to the Safety Advisory Group and lots of discussions. We had no concerns around that notice. There was subsequently 2 further notices, and one of those was during the period that the application had been submitted. And as part of the consideration of the temporary event notice, there was consultation with the applicant at that time, because the event took place during the Ebor Festival, which I'm sure most of us in the room here are very aware it's a very busy period in York. And we deemed that as part of that, both for the safety of the venue itself and for all the people that would attend for the Ebor Festival within York, that it was necessary to put door staff on for that. The applicant did comply with that. And again, no issues were reported from the venue for that event. There was a subsequent further temporary event notice in September on a Thursday evening where there was no objection. And then we received a temporary event notice for the 31st of October, which was the Halloween evening that's been highlighted, where officers did attend. There was some engagement with the applicant around that to look at what conditions. Because of the information that the police had about that event that was running and other events that were running in the city, we needed to know that there was going to be additional safeguarding measures in place. And we were concerned that there weren't now. That notice was objected to by the police. A hearing date was set, but the applicant subsequently withdrew that application. The event went ahead with non-licensable activities. And as I've already confirmed, there was no incidents reported on that evening, and there was the engagement, as we've already highlighted. I hope that answers your question, Chair.
Can I just add as well, for a point of clarity for anybody that doesn't realise this, is that when we're reviewing these temporary event notices as police officers, we can't impose any conditions, of course, unlike a premises licence that will have conditions. So we couldn't impose any conditions. So our only option is to make that objection, to give that opportunity for those conditions to be imposed where we've got any safety concerns.
And I guess my question is, given that those didn't have those conditions, were there any problems that arose as a result of the lack of conditions? But it sounds like
no, and obviously the event took place without alcohol, because the notice was withdrawn.
Thank you. A couple of very quick validations. The police didn't ask if they could go inside on the Halloween event. That was they didn't feel the need to ask.
No.
And Paul indicated children could be there at any time, but just to confirm, they can't after 10 p.m. with the conditions that are currently here.
If that condition is minded to be granted by yourselves, then no, they wouldn't be.
And likewise, challenge 25 isn't in their application, but they have agreed that's something
We
they're
have
happy to
proposed the
accept.
wording of that challenge 25, which you know, we had discussions to make sure it fit everybody's requirements, and we're happy with that.
Fab. I'm going to ask this to multiple parties, but the Equalities Act, you mentioned there's some weighting to that this isn't just about the cumulative impact area. What weighting would you grant that against things like the CIA policy and these other licensable objectives?
I think it's very important to look at, obviously, the public sector equality duty, which from a North Yorkshire Police perspective, we do take that on board. We're here to serve the community and we're here to protect the community. But we also have to look at the other policies of crime and disorder and the wider community as well, and ensure that we're not undermining any other policies, and we work in line. And I appreciate council have highlighted that the law can be sometimes very dry. From a police perspective, we are in law enforcement, and we want to ensure that anything that does operates in line with legislation and with policies to keep people safe. We've not said that we don't support this style of venue. I think we made that very clear in our police representation. And I do think that that balances the public sector equality duty, but I would ask you to be minded in relation to your policy, it's your council policy, but also in relation to the Licensing Act itself and the Section 182 guidance.
Okay. I guess this is a quick one as well. You said the police need to trust the management of a venue. Would you also agree that the police need to earn the trust of the management of the venue?
I absolutely agree with that. And I think, and I don't, as council has said, I don't want to get into tit for tat. What I'm trying to demonstrate is I feel we have worked really hard to try and to agree conditions with this. And the ethos of the Licensing Act is working in partnership. And it's very key to work in partnership, because if we can't work in partnership and someone can work with us at a very early stage, then that's where we find there's a breakdown and problems can occur. And also we work very closely with our other partners. So we work very closely with the licensing authority. We work very closely with public protection, and it shouldn't be a case of dividing those responsible authorities. We should all work together for one common purpose, and that is to keep everyone safe. And I think that is the aspect that we have tried throughout this application to demonstrate, is that we want to work. We haven't walked away from this. We have tried to obviously set our position out, but also to try and see the need from the applicant's perspective and the need from that community as well. But it does not help when we have comments made that are inaccurate about the police when we should be trying to work together and not divide.
Thank you. Final one from me. When I read the emails talking about agreeing to the conditions under protest, the way I read that was they don't think the conditions are necessary, but if it's what they need to put in place to get approval, then that's what they meant by under protest. And from my experience on the licensing side, that feels like a relatively common occurrence, that people don't really want the condition, but they feel like if we're the licensing authority and we say it's needed and that's useful. It felt like you guys took that as a much stronger comment under protest.
I think in relation to that, what we wanted was total transparency. We don't want to be seen, because it's not the police that grant the licence, as has already been highlighted. It is yourselves, and we don't want to be seen to saying to someone, you know, you're accepting these conditions. You know, what we wanted total transparency. What we have not experienced in the past is an applicant coming back and saying under protest that. So I felt, and I consulted with our legal team, that for total transparency, and if the licence is to be granted, that we didn't want at a later stage the applicant then to say, well, I felt I had no choice and I was forced to this and I couldn't necessarily maybe meet this condition. So for transparency purposes, that's the reason. It's, you know, it's not the police that grant the licence. Obviously it's yourself as the committee that look at that. And I think then in fairness then it shows that actually if you deem those conditions are proportionate and appropriate, or to change them, that all that's been highlighted for transparency reasons.
Thank you. That's everything from me. If you guys got any other questions? No, I'm minded to take the public protection 15 minutes and questions before we then have a break, just making sure that everyone's happy to do that. Okay, great. In which case, can we go into the public protection case? Thank you.
Thank you, Chair. As you'll have heard already, the cumulative impact area is an area designated by the council in its statement of licensing policy, where evidence shows that the cumulative impact of the number and concentration of licensed premises continue to adversely affect residents, visitors, and other businesses, and therefore adversely affect the promotion of the licensing objectives of prevention of crime and disorder and prevention of public nuisance. Within this area, when applying for licenses, the onus is on the premises license holder to demonstrate that the licensing objectives will be met and that their proposed activities will not result in an escalation of crime, disorder, and public nuisance in this area. The premises is an old church building situated in the cumulative impact area, where there are already a number of other licensed bars offering regulated entertainment in the area. There is a hotel to the front and rear of the premises and residential flats to the rear of it, as well as residential flats in close proximity to the premises. In its current form, this application would allow live and recorded music, the performance of dance, plays, sporting events, and the showing of films and other similar activities involving amplified live music and sound in the cumulative impact area until 3 a.m. Sunday to Wednesday until 4 a.m. Thursday to Saturday. All this inside a building where noise breakout levels have not been assessed by the public protection team, and they may pose a public nuisance due to both noise escape through the envelope of the building and if doors and windows are left open through them. The applicant is required to demonstrate that they have considered the potential risks and the impact of the application on the promotion of the licensing objectives, and that the operation of the license will not add to the cumulative impact. As we've already noted, in its current form, the applicant has not provided sufficient measures or conditions to demonstrate that the granting of this application will not add cumulatively to the already significant amount of public nuisance impact within the CIA. Therefore, in its current form, the application is contrary to the cumulative impact policy. Although the applicant has agreed to the imposition of some conditions to prevent public nuisance, as set out in the public protection representation contained in the original agenda papers, the applicant has not agreed to 3 other key conditions which the public protection team considered are essential to demonstrate that the proposed activities can take place at the premises without resulting in a public nuisance. A fundamental concern is that there is currently no approved noise survey at the premises, and the public protection team have been unable to assess whether the construction of the premises is satisfactory at preventing noise breakout of sound from regulated entertainment and whether noise insulation measures are required. The public protection team received the applicant's noise report at close of play on Tuesday this week. That left only yesterday to assess that report. That is insufficient time for the public protection team to enable a proper and conscientious technical assessment of the report as is necessary. I have noted from the applicant's recent noise report that the noise measurement measures were actually undertaken on the 19th to the 22nd of September. Yet for some reason, the report was not finalised, it appears, until 6 November and was only very recently submitted to Democratic Services. This, although the subcommittee adjourned the premises licence application on the 29th of September at the appellant's request to enable a noise report to be prepared. The expectation was that the noise report would then be provided to public protection in a timely manner to enable them to properly assess the noise impacts ahead of this hearing date, rather than provide it far too late for this hearing. In the circumstances, public protection's position is that additional conditions are considered necessary and remain as previously submitted. These are first condition that all doors, except for immediate ingress or egress, and windows shall remain closed when regulated entertainment is taking place. This is, of course, a standard condition to prevent late night public nuisance in residential areas. The second condition, and these are the ones that have previously been submitted, and which the legal representative for the applicant has said are no longer required. The second condition is that no regulated entertainment shall take place at the premises until either environmental protection team of City of York Council are satisfied that the sound insulation performance of the building envelope of the premises is satisfactory at preventing noise breakout of sound from regulated entertainment, or until a detailed scheme of noise insulation measures have been submitted to and agreed in writing by the public protection team of the City of York Council and then implemented, at which time this condition shall be removed from the licence. This condition is considered necessary to allow the applicant to demonstrate what noise levels are achievable within the premises and to carry out any necessary sound insulation works to prevent public nuisance. The third condition, as previously advised that the public protection team require, is that within 2 months of a written request by City of York Council's environmental protection team, a tamper-proof noise limiting device shall be fitted to the sound system within the premises, and all music played at the premises must pass through this sound limiter at a level first agreed in writing by the public protection team. Thereafter, the device shall not be altered or modified without the prior agreement of the public protection team, and this device must be of a type and in a location approved in writing. This condition is necessary to ensure that noise levels can be suitably controlled if it is appropriate to do so following the noise assessment required under the previous mentioned condition. These three conditions do need to be imposed on the licence because if a licence is granted, because it is not known at this stage whether the building is currently suitable for the regulated entertainment that is proposed, especially into the very early hours of the morning, as the building may not be suitable for containing noise. These conditions will allow the premises to function as a community venue and bar while safeguarding the nearby residents from potential public nuisance. However, without these essential conditions, public protection cannot support the application and would request that the application would need to be refused on the grounds that the applicant has not yet demonstrated, as required by the cumulative impact area policy, that they will not have that the operation of the licence will not have a negative cumulative impact on the area in terms of the prevention of public nuisance objective. And just to clarify that these conditions requested are necessary to the 6 conditions that have been agreed by the applicant as set out in the public protections representation at the bottom of page 69 and top of page 70 of the agenda. A condition for a noise management plan and for a dispersal policy are still required, as currently there is no agreed noise management plan or dispersal policy. Thank you, Chair.
Thank you. Well within time. We'll go for questions in response to public protection, starting with the applicant, please.
Thank you. Ms. Brannigan, sorry, I think you're referring to the page numbers on the old agenda.
Yes, I think there've been so many agendas, sorry.
And you're a lawyer?
I'm a counsel, senior solicitor, yes.
Yes. Your client, is anyone here from public protection?
Yes, public protection are 2 officers.
So they've
here.
not been able to read the report or provide an
right,
opinion?
far too late, as I've said.
Bless, that must be difficult.
It is 16 pages. That is of no fault of the licensing of the protection team.
Now, in terms of condition 1 that you want, as the senior solicitor, it's effectively a power grab, isn't it? An unlawful power grab that you're asking for. Because what you're saying is, I don't care whatever decision the committee make, unless environmental health is satisfied, we're not going to allow this licence. So you're taking it completely out of the democratic sphere of determination, and you're making this officer, who hasn't even been able to read a short report this morning or over the past couple of days, responsible for the grant of this licence or not. That's just wrong at law, isn't it?
No, I disagree with that. And this is a condition that we've applied on other premises licences where there has been no noise assessment being provided. I don't consider it would be an unlawful condition. The situation we are in is of no fault of public protection. If you think this is an unsatisfactory position, then with all respect, your client, it's your client's fault, because this noise report was requested by public protection back in August. We have been waiting for it. I understand that the noise, some of the noise assessments were carried out by the organisation appointed at Dragonfly in September. Yet for some reason, the report was only finalised and sent to the the Democratic Services just before this hearing, leaving no time at all for public protection to properly consider it.
I appreciate you're all busy. But in terms of your unlawful condition, it may be a common legal error that York City Council make, but you're maintaining that that's a lawful condition, are you?
We're maintaining it's necessary if a licence were to be granted now. The alternative would be to adjourn this application to allow for the noise report, which the subcommittee, I think, anticipated would have been provided, and the authority had an opportunity to assess ahead of this hearing. But this situation that we are in, I think the alternative would be to further adjourn the application.
No. Sir, I think everyone else has had time to read the paperwork, and it is voluminous, and we've all had notice of this hearing. So I'll leave it to your determination. Of course, paragraph 9.12 of the section 182 guidance says that you're going to be led by your experts. Now, your experts can't give us any evidence because they haven't had time, and I appreciate the workload, but we can all read, and that's fair enough, and I'll make legal submissions on that. Just a further question about the noise limiting device. I assume your officer hasn't been able to think about cost benefit and proportionality, and I'm specifically referring to the guidance on noise limiters at paragraph 2.23 of the section 182 guidance.
Yeah, that was taken into consideration about the cost implication of the noise limiting device. That's why we're really hoping that earlier condition about the premises being suitable for use. If we know that and we can read through the report, we'll know whether it's required or not required. We are actually trying to help the applicant with this one so that he doesn't incur some extra cost that is not necessary. He doesn't have to do it if he doesn't have to. But if it is required, then we can then request that to go into there. So it's more about actually trying to help the applicant with this one. Once we understand whether the premises is fit for purpose as a building to attenuate sound.
It's a short report. How long do you need to get through the 14 pages?
Chair, we have my clients have not had an opportunity to assess a technical report. These are things that cannot be done in short order. It is a technical assessment. It needs proper consideration. I understand that often it involves a little bit of toing and froing and queries going back to the author of the report. This is not something that can be done in short order the day before the hearing.
Thank you. No more questions. Thank you.
Police, any questions? Thank you. Technically, any questions from the licensing authority?
No, thank you.
Okay,
Question myself.
Joe and Phil. Leo again. Andrew.
No questions.
I believe it's now Big B rather than Debs. And then Jake.
No question.
Okay, councillors, any questions for public protection?
Yeah, I'm just getting a bit confused. So if when you've looked at the report, you find that everything's all right, then you would say, okay, we can relax some of these conditions that we've imposed. So I'm just wondering about the order of doing things and how temporary a temporary condition is, and if that's what it is. And
Yes, absolutely, Chair. What the situation is we're not sure about it's an old historic building, so there may be weaknesses in it. We haven't reviewed the report. We don't know whether it's been theoretical noise inside, whether it's been actual noise tested from it going into out. We don't know basically whether that can attenuate that. So
there is a risk without this condition that you'll end up with a potentially a public nuisance, especially in the early hours of the morning. However, with this condition, what it would allow us to do is work with the applicant to look at this review and review this noise report. Let's say, best case scenario, we look at it, we're absolutely in agreement, there's no queries with it whatsoever. What would happen is then that would drop off, we'd be satisfied. So in a week or two, we're happy that this has been, that the building's suitable for use. Therefore, this condition was drop off. However, if it does need some to and going back to work with the noise consultant, we can do that. I'm pretty confident we could turn that around and we could work with the applicant. But it does give them the opportunity to work on it if we need to protect the residents if necessary, but also once everybody's satisfied with that, it drops off.
So just clear, so is that just 2 and 3 that could be affected? Condition 1 isn't going to be affected by the outcome of the report?
I think the doors and windows need to be closed, really. If there's no acoustic lobby in there, for example, well, last time I went to the bath, there was no acoustic lobby. Every time the door opens and shuts, the noise will come out, and that'll be all the way through the night. So I think that condition definitely is
staying
to go on there, yeah.
But 2 and 3, the ones you're saying that having gone through the report, you think there's a possibility that these 2 could just drop off because the report that's been done by Dragonflies.
I think once we review the report, I can't give a comment.
No,
on
that's fine.
professionally because I haven't read it. It would be
Yeah.
improper to do so. It would take time to review that. But that condition would allow that, let's say that report is fine and we're happy with it, then the condition drops off.
2 and 3.
If we're not happy with it, then we work with the applicant to get that done while still allowing it to have a premises license in the meantime. The noise limiting device, absolutely, yeah, we're trying to curtail any costs that aren't required.
Thanks. I appreciate my microphone is not picking me up very well. Your microphone's not picking you up quite well. If you could move it slightly closer, just so that people watching online can definitely pick up the sound. We had some comments around the kind of fire safety, maximum capacity piece, courtyard capacity, the letting people out in case of fire and metal gate. Is any of that aspect related to public protection? I don't know if that's in your remit or not, but.
Thinking about it, not really. I mean, what we're thinking, if the door was to be locked and closed locked, then that would obviously be dangerous for the fire regulations. However, if the doors can be opened and are openable, especially if you have an acoustic lobby at the back, then that would be in line with other premises. And I mean, I'm not a fire expert. I can't identify about that, but yeah, that would be for yourself to make a decision on.
That's not a problem. Do you know what the nearest housing is in terms of distance from the venue? I haven't been able to get that from anyone ahead of the meeting.
Yes, it's out the back where the old George Hudson Street offices were. Above there's been converted into residential, so it's directly at the back, and also the hotel is almost abutting onto the premises itself.
So it's sort of 50-ish meters in sort of northwest and southwest from the premises, roughly.
The going behind the premises, yeah, but to the travel lodge, it's literally almost adjacent to it.
Okay. And do we have any objections or complaints from any residents for any of the existing temporary event notices that happened in terms of sound or other nuisance or anything like that?
No, you didn't check.
And final one from me is the noise impact assessment versus the 3 conditions, sound limiter, etc. Just wanted to check if all 3 of those conditions were granted, would public protection have any objection to this application for the times that have been requested here, or is it just those that would be of concern?
No, it's just to put those conditions on, and if they were on, we'd be happy with it.
Okay. Thank you very much. Nothing else from me. Any other questions? No. We will take a 10-minute adjournment at that point. We will come back. I think if we're fast, that will be the last break that we need. But yeah, come back in 10 minutes and the web broadcast will pause during that time as well. Thank you. Great, we'll go straight into the 15 minutes for the case of the licensing authority, please.
Chair, thank you. Before I do that, would it be possible to clarify the last answer that Public Protection Officer gave to your question about TENS just before the break?
That seems reasonable.
You asked about whether there have been any issues with the TENS. I think the answer was no, which is correct, but I think it's important to clarify that the TENS only run up to 2,300 hours.
Thank you. That's useful. I've also just remembered that I had changed the order of events during the break, and I hadn't told you guys, but I had checked with the applicant and our side. We missed the questions to the applicant section from members at the start of the meeting, and the point was made that it would be appropriate or more appropriate for us to ask those questions now than after closing statements, so that there's a chance for people to absorb those and incorporate them. So if that's okay with everyone, we'll tick off any member questions that we have for the applicant now based on the applicant's case. I know it's out of order and apologies for that, but that was my oversight. So yeah, colleagues, have you got any questions for the applicant that I glossed over at the start?
Thank you. Just this gate that's figured large in a report, and also I saw in the papers as well. Can you sort of talk about how it's opened and operated? And
Absolutely, and I have a note about gates, Halloweens, and non-alcoholic punch here. So the police were invited in, so they could have seen the gate. So what you have, in fact, it might be worth looking at the plan so we can go through it. Though I appreciate, Councillor, you've actually visited, haven't you? So if we look at the plan on page 77, you'll see at the top of 77 there's the sort of green arrows. So the front door opens out and to the right, and that's a requirement for fire risk and fire safety. So that can't be kept closed. So public protection need to take that into account. Otherwise, their advice to you is to create a fire hazard. So that opens one way. You'll see at the back, there's a further door. Now that's the fire exit from the neighbouring premises, the nightclub. So that allows for a way through. And then you'll see there is a door that goes into the venue proper. Now that can be kept closed. That can be opened and closed. So it creates something of an acoustic lobby, but it is kept open. So that opens outwards. There is a gate which opens inwards, and it's on a latch. So you just push it. It is attached where you see those red dashes. It is attached by one of these sort of hooks. So once the venue wants to keep that open, they just clip it on and it attaches. So depending on the nature of the venue, depending on the kind of intimacy that they want, that can open and close, but you merely just push it. I think what was key actually to the police evidence, and I thought was really helpful because it helped me understand my client's case, is they said the officers weren't sure about whether they could go in or not because they didn't want to be seen interacting with the venue. And I just get the sense from today that, you know, my clients are afraid to talk to the police. The police are afraid to talk to my clients just because everyone's so concerned about sensitivities. It's only us lawyers that are managing to be kind of rude and trample over each other's feelings. And I think that's the reality of it. Just asking these simple questions sort of demonstrates these facts. So that's how that gate works. In fact, there's also a gate in front of the bar area and at the back that goes into the car park area. And insofar as the report and the condition is concerned, you'll see that public protection asked, and we've agreed, that the rear area should be closed by 2200 hours. That's page 98. For those of us that have read the Dragonfly report, it's clear that it's the rear door that needs to be closed. And what my suggestion would have been in closing, and I do now, is that condition 2 on page 98 says that the rear door, except for ingress or egress, and windows shall remain closed when regulated entertainment is taking place from 10 p.m. And that is actually consistent with what public protection are asking for, and is consistent with the conclusions reached by Dragonfly, following a methodology that was agreed between them and the local authority. So it's a common methodology. So hopefully that explains the doors, access, gates, and perhaps as a message to police, if you're invited in for a non-alcoholic drink, do please come in. You'd be very welcome. Thank you.
Yeah, just to follow up, a closed door just means the door that is physically shut, but
Yes.
you can bash into it and it'll open again immediately. It's not closed, like locked, closed
No,
or anything
exactly
like that.
that.
So, yeah.
And the problem with the front door is because it opens outward. If people are going to push on that door, what you're effectively doing is saying, just push on the door and kick whomever is behind.
Yeah, ouch.
Yeah,
Yeah.
exactly. So it's just not practical. Thank you.
Okay. Children protection, you do cover it briefly. Have you anything to add? Because it's a bit weak. You've got films for 14-year-olds, but restricted, and then you've only got limited sort of conditions about children going into this venue. Is there anything that you feel that could be added to make it a little bit stronger?
I'm happy to add challenge 25. I think it was agreed at some stage in any event, which the police have asked for it. But there is a suite of conditions, and I think the challenge for this venue is because it's not a vertical drinking venue, but it is set up as a community space, and it wants to be flexible. It wants to be able to have family events during the day or even into the evening. So having that level of flexibility, which I think is probably why a risk assessment is key in looking at the event plans. I think that's why it might have felt a little bit amorphous for the responsible authorities. But the reality is, what is at the core of protecting children from harm is that children to be accompanied by adults, not to be admitted beyond a certain time, certainly to have an appropriate proof of age policy in place, and then depending on the nature of the event. So if you were watching, I don't know, an 18 film, then there would be someone at the door saying, you can't come in, only over 18s, just the way a normal cinema operates. So other than challenge 25, I can't really think of anything that could be added to the suite of suggestions on page 76.
Okay. And so the capacity, 120 is based on what?
We've had a fire risk assessment. I apologise. I think what's happened, sir, is that there's lots of paperwork, but there's been a real unwillingness to share. And certainly after the last adjournment, I encouraged my clients to perhaps withdraw a little bit and wait to come to you, because I think councillors act a little bit like Relate, and they sort of pour oil on troubled waters. And so far this morning, we've had a great conversation, and maybe this is the first opportunity where all the parties are realising, oh, we're actually on the same side. That hasn't been the case. So we have a fire risk assessment, and it's based on that, and we're happy to provide a fresh fire risk assessment if needed.
Do you have a copy of that with you?
I think I do, yes.
I'm just wondering if there's any opportunity for circulation very briefly in case casting eyes over that gives a little bit of assurance. That's out of the ordinary.
I know I can't. There are legal rules about what I
Yeah.
can do with this. I can talk about it, but I can't do that.
There is, if you want to circulate any evidence, then at the hearing, it has to be done with the consent of all members of the parties, sorry, not members, all parties.
Would people find it valuable to have the fire safety assessment that's here circulated? Would people find it inappropriate for it to be presented this late in the day?
Yeah, I think it would be very difficult on the basis as well that was one of the points that we've made. Everything's been served very late. This would be crucial information, which would be great to serve. You've heard the difficulties that public safety have had because the report for the noise was served so late, and there's been given no explanation about why that has happened, only criticism from the applicant that it hasn't been. And so I wouldn't want the police to be put in the position where the accusation would be, well, you've had the information, why aren't you considering it now?
Yeah, understood.
And there's been no reluctance on the police at all to serve information on any party, just for clarity.
And there was a request for that it was calling out the lack of that fire safety capacity in the paperwork ahead of time.
So as you can answer questions.
Well, I can answer questions, which is so odd. The regulations aren't very helpful. If the license is granted, and I'm not suggesting anyone's made a decision one way or another, it may just be that the condition could be added that a fire risk assessment to include capacity is lodged with the licensing authority within 21 days.
So as you've seen it, and I can ask you questions, was that based on 120 seated people?
No.
So you're, 'cause only in the document in your submission, you've got 12 people on the mezzanine, and that's the only number. So what's the 120 based around then? Is that?
Which is based on our application and the risk assessments that have been done for the TENS, including the fire risk assessment.
Yeah, but is that 120 people just milling around then?
Yes,
Right.
yes, it's not seated. It's a maximum capacity. So when there's a stage in the venue, if there are tables, if it's set up like a cabaret space, then that capacity comes down. Absolutely.
So if you set up for cabaret with seats, how many seats do you have? How many people sat down watching?
I think it was about 80.
Yeah, 7, because you've done those already.
Something like
70 is a
80.
maximum of 80.
Yeah.
Cool. And you've asked for the times you've asked for. Why have you chose 4 o'clock?
Partly parity, partly flexibility. And as you can see, the licensable activities end a lot closer than the sorry, they don't. Yeah, it's just been partly for parity and allow for full flexibility.
Parity with?
Or just other late night opening venues.
But next door's 2 o'clock, isn't it?
Well, next door is, but you have no gay venues. And so the idea is.
So you parity with what other gay bars in the rest of the country?
Well, yes, and a late night offering that allows for a full, genuine late night offering in the nighttime economy.
Right. I thought I'd read that you wanted a gap between other bars in the rest of York kicking out and not then causing a nuisance as you disperse from Little J. Have I read that correctly? So it's to give yourself a bit of safe time that
yes,
the drunks have gone home in their taxis and then you can leave in your taxis.
And that's the point on page 66. The opening hours are an extra half hour for that. So quite often the licensable activities will end, but the idea of being able to have the venue open as an option for non-licensable activities, albeit into the early hours, provides a buffer, which is considered important.
So there's a need that you have to drink in that buffer, or you can stop drinking earlier, but still stay open longer to give yourself that buffer.
So consumption isn't an alcohol isn't a licensable activity, as we all know, and there is a drinking up time of half an hour. So you've seen that we've agreed with the police that even if we bring licensable activities to an end, say after a cinema night or a cabaret night at 12, 1, 2, or whatever it may be, the drinking up time will be half an hour, albeit the premises can stay open later under its opening hours. So I would ask you and your colleagues to grapple with the question of hours of licensable activities separate to hours of opening for non-licensable activities.
Cool. So I'm just trying. So it's trying to get the balance between safe space and having a good time drinking. Is that right?
Yes, that's probably fair. Yes.
Cool. Thank you. If you've got some, I might have some plans.
Yeah, I've got a few more. So if you've got other questions, then I'll come back to you, of course. One just to clarify something that you'd said that I had not fully grasped the entire wording of. You're talking about the police conditions, and point 3 was around the door staff, and there's something around alcohol licensable activities from 10 p.m.
Yeah.
Was it that you don't need door staff before 10 p.m. even if it's licensable? Or was it if the event runs beyond 10 p.m. or what was the specifics on that, please?
So when the venue is opened for alcohol licensed activities, there then would be a minimum of 2 SIA registered door staff from 10 p.m. So when it's an alcohol-led event, effectively. So if you're running a dry Halloween cabaret night, for example, you know, I think it was Paul that was telling us about how he changes when he's drunk. You know, the idea being that it's according to the police, it's alcohol that creates and leads to antisocial behaviour. What we're saying is that if there is no alcohol, then there wouldn't need to be a need for an SIA. Things like proof of age, checking people, fire safety, all of that would be covered by the general manager.
Yeah, I mean, I think they were saying that alcohol exacerbates public nuisance rather than being the sole cause. But yeah, I'm just making sure that what you're seeking is zero door staff on community events that are without alcohol, and when there is alcohol, only from 10 p.m. being mandatory, which is different to the discussions that took place by email and some of the other bits in here.
And,
I'm just making sure I understand what you're saying.
With the police, that's the significant point there.
Thank you. The outstanding noise and the late entry paper, I guess, just validating that you understand that we aren't necessarily able to take your word for it, and that we do have public protection there for a reason, and their approval of and validation of that paper is probably a useful thing.
So I hope that you and your colleagues can read, and you'll see the conclusions at page 21 of the supplementary agenda, and you can see there just quite clearly, as we all can, we don't need to be noise experts to read this. It says, remembering that this is a format and an approach agreed between Dragonfly and the council, it says that the impact will not be significant, and that the typical noise levels considered at their worst would fall far below the lowest observed adverse effect level. So on that basis, I mean, the whole point of these reports is that lay people can read them. On that basis, you can see that the outstanding condition 2 can be amended, as I've already suggested to Councillor Hook. Condition 3 does fall away because, as has been accepted, it would be disproportionate, and you'd be applying the guidance at paragraph 2.23 of the section 182 guidance. And insofar as condition 1 is, I think that's an unlawful condition, but in any way, in any event, you have a report. If we were to become a source of noise nuisance or impact, if the license were granted, then public protection would, of course, be able to review us.
Yeah.
So you can rely on this paper.
I understand all of that. I think there's obviously a distinction between my ability to read and understanding what that assessment says versus the ability for technical experts to do due diligence on the content of the paper. But I appreciate those points. Well, we've talked about fire safety maximum capacity. We haven't talked about the courtyard capacity. Is there a maximum capacity fire regs wise in terms of courtyard?
It's in addition to the 120.
Yeah, I think that to be used is going to be limited. I think it's in here. I don't know what the full capacity is. It's used as a smoking area, and I think in the future there's an intention to apply for a pavement license, so they can use the outdoor space and get tables and chairs there.
I'm just, I guess, validating that is included within the 120 maximum capacity that has been applied for in the application.
No,
No.
The fire risk assessment, the 120, it's actually a 150 maximum capacity based on the floor area. It's limited to 120 based on the size of the fire doors and the fire route, but it's an internal capacity. Anyone in the external area is in addition to the 120.
Thank you.
Okay. I've got other questions about capacity, I guess, both on that and you mentioned 80 capacity for seated community events. I was just wondering what your strength of feeling was around conditionability of both of those as maximum capacities, if they feel appropriate to condition, if you're saying those are the maximum capacities you'd be implementing anyway.
Given that we've put them in our paperwork, we're confident that those are the correct numbers. So you'd be open to condition that.
Okay. And conditionality of the monthly calendar risk assessment in advance for advice that you mentioned, is that something you would want as a condition, or is that just something that's a general offer to?
I said it can be offered as a condition. I think when I was talking about that, the police were nodding. So what typically happens is that there's a rolling events calendar. For example, there was some fresh bookings that came in just yesterday. So that would be updated. We can supply it to the police. We can identify what events need to be risk assessed. So typically, is there alcohol? Yes. Okay, well, you need SIA. Will there be children? Yes or no? If the answer is yes, then you need proof of agent and so on. And that can be kept up to date with the police. And then if the police want to advise that something has been risk assessed too low or even too high, they can get in touch with the premises with that advice.
Thank you. I guess a few questions about the cumulative impact area policy. I guess the prominent one is, do you guys understand and accept that within the cumulative impact area policy, the onus is on the applicant to prove to us that there aren't any cumulative effects? appreciating that we've talked about the balance of that, but that is.
Well, yes, that's only just one policy, isn't it?
It is. I'm just. That is what
I
that
think
policy.
we need to be careful of is making it the policy. So, for example, an equally important policy is your vision, which is recorded at paragraph 4.4 of a safe city centre, which is welcoming and accessible to all. That is just as important a policy consideration as your cumulative impact policy. It's not that this overrides. And actually, just to sort of correct some of the submissions you've heard on the public sector equality duty, it's been suggested that somehow the public sector equality duty sits alongside these other considerations. That respectfully is quite wrong. The public sector equality duty is an overarching duty that applies to all your functions, whether it's licensing or building regs or so on. So there should have been a public sector equality consideration for each aspect of the statement of licensing policy. Each of these responsible authorities should exercise their public sector equality duty, as indeed you are to do so freshly. So in fact, looking at this from purely a public sector equality duty perspective is in and of itself sufficient basis for you to grant this premises license. So I know in licensing we tend to fetishize a cumulative impact policy and make it the alpha and the omega, and that of course is quite a wrong approach when there are other considerations.
I appreciate that. I'm specifically just within the CIA policy, just making sure we understand that there are, of course, other legislative aspects and other policy aspects. And for example, we haven't mentioned, but the vision for the city, the overarching city strategy also puts a lot of emphasis on this equalities aspect.
And the report makes it clear that there would be no additional impact in the conclusion. So from the point of view of public nuisance and noise, it says no additional impact.
Specifically around the types of noise coming from within the property, but there are, of course, other types of nuisance. The police mentioned that if it weren't an LGBT plus venue, it would basically be rejected outright. Would you agree with that assessment, or do you think that's not?
Well, I hope the police would actually apply another key policy consideration, which is each case on its own merits. So the idea that that a CIA comes like an iron curtain on all applications is wrong at law, and I know you don't accept that. So that's probably not fair. So I get the sense that everyone here, or nearly everyone, has an open mind on all these applications. But what I got from the police statement was an agreement that the public sector equality duty is sufficiently exceptional to allow for an application such as this to be granted in an area of community impact, which is consistent with experience in other areas around the country.
Would you agree that these are scenarios that are plausible and valid? People going elsewhere in town drinking and then coming to this venue after some drinks elsewhere, people drinking at home or a university campus and then coming to the venue, people coming to the venue and then afterwards deciding to go for another drink elsewhere in town, dozens of people getting taxis outside the venue after closing. They all seem plausible, yes, no?
Yeah, they seem plausible.
On page 85, 86, and probably repeated a few times in other bits of the papers, are the bits of the cumulative impact area policy
86.
that are 85, 86. Yes, on the bridge of that page divide, which are the aspects that may make an application be considered more favourably. Within that, there are a number of different things in there. For example, no vertical drinking. Now, we've had a bit of discussion about the vertical drinking aspect. The application as it stands would enable vertical drinking, but I guess the conditions by all parties are saying that's not the purpose of the venue. I'm just curious as to why none of those aspects have been incorporated. And I'm thinking, obviously things like customers seated at tables would be something that could be mandated to add favourability on the CIA policy, but also explicitly when most of the licensing options are ticked, the above ambient temperature food after 11 isn't ticked, which counters what would be able to kind of add emphasis in this policy. I just want to get your take on whether there was a reason none of those conditions had been proposed.
The premises is not a restaurant. So
Sure.
Table service, meal and so on would be inappropriate. The flexibility sought for a music, arts and performance space is just that. And as some of you may be familiar, operating a music, arts and performance space is economically challenging. You're not going to make money from live music venues and performance spaces. So the bar is a really important consideration. So I think that needs to be acknowledged. I do understand that in in phase 2, if you survive phase 1 as well as pavement licensing, there is a view to look at getting late night refreshments authorization so that they can have that sort of coffee shop style element to it. But it was felt on my instructions that the community use, albeit with a bar and that capacity to run as, you know, a nightclub on pride events and so on, as needed, was sufficiently different from a vertical drinking establishment, and particularly with the conditions suggested by the police, which I certainly agree with, meets that objective.
Yeah, I guess singly on 2 of those specific points, yes, it's not a restaurant. Table service is slightly different, but no vertical drinking and customers being seated at tables is something that's an option here that obviously hasn't been accepted. Ditto with you're saying about, you know, financial and the ability to do more. The option for late night refreshments wasn't ticked, which would have given more flexibility in addition to adding some weighting on the CI policies.
I think the risk assessment and the event management diary, the event diary that's going to be submitted to the police, is actually a very important condition in regard to this. Because if the police go through it and they think, oh, look, they told us they're going to run a community venue. Not I've had these kind of clients in the past before. Yeah. And then they tell you all about their live music and their poetry recitals. And then they submit a diary where every month is, you know, club night extravaganza. I mean, that's a review, isn't it? Because then it's not being used as a community venue. So I think you can take assurance from the fact that the diary of events will demonstrate, okay, here we go, we've got the poetry, we've got the sort of wigs classes, we've got the sort of live mics, cabaret and so on, which will speak directly to this concern in 9.14, which is to be a genuinely diverse venue that isn't just about vertical drinking. So I think that risk assessment and the publication of that events plan will help ensure that doesn't happen, because they'll be in breach of condition 1 if they.
It certainly gives confidence of the purposes of the venue. I guess it doesn't prohibit the ability to have a vertical drinking night that, you know.
And I've not said that we won't. You know, pride events and parties and so on. That will happen then, of course.
And that's, you know, again, it leads into the what ifs of what the licenses allow or don't allow. I've got a few more questions, but just going to colleagues for any others first.
I've found one. When the police put some conditions down and there was signed under protest, and I love email because you can interpret it whichever way you like. We're all left in that world. Do we know when the word under protest meant? As you know, Councillor Rose mentioned, he read one way, everybody else can read it a different way. So just as we're all speaking nicely, what was meant by under protest?
I honestly think that's the case. I honestly think that when and I've represented many people from the queer community, very widely ranged. There are certainly people of a certain generation and people from a certain experience that see the police and they just assume that the police are representative of a very oppressive, prejudicial conduct, which I appreciate is not the case with these individual officers. But of course, up and down the country, we know that homophobia is an institutional feature of many police forces. Again, I'm not targeting anyone, but if you are from a culture that is part of protest, activism, visibility, feeling particularly vulnerable for various reasons, then the moment you see a police rep saying, you must do this, it feels really antagonistic. And I think that's at the root of it. And I think this is why perhaps the officers, and I have represented police authorities as well, where they don't feel comfortable going into a premises, because turning up in uniform with your body worn cam, videoing people on a night out for Halloween just doesn't look nice. So the police don't know whether they can go in and have a punch. We don't know whether they want them in, because it's like, well, why are they recording us? And so that level of sort of trauma operates on both sides. And I think it's why I'm here, actually. And the conversation that we're having seems entirely reasonable. I almost feel otiose, not that I admit to that readily.
So when you say you agreed to all these conditions, that is now happily?
Well, they were always agreed to, even from our first meeting. There was a quibble with Graham over the community event space and the quibble around the SIA, the deployment and the use of license. But in principle, there's no, it's about the practicalities. It's just those two things really that are outstanding.
Yeah, I mean, just to add to that, we're a multi-use business model. York has a very small scene. It's not got the ability to have several LGBT venues. Some are clubs, some are pubs, some are community centres. We're trying to be all things in the one space. And with that, we were wanting a flexibility to do the risk assessment of each particular event that we might have on, because it would be quite intimidating and overreaching perhaps to have 2 door staff if we were having a knitter natter or some type of craft event on an evening. Whereas I can understand that you would always have 2 door staff from an early time if you were having a nightclub venue in York. But we are trying to do lots of different activities which would require a different risk balance for us to assess. So the issue really was that having the blanket mandated requirement wouldn't fit for us doing different types of events. It would mean that we wouldn't be able to put on the events we may want to.
Thank you. And Sarah, we've given you our events programme, so you can see the real variety of events that are proposed at the venue.
Sorry, I didn't have my microphone on for all that. But
okay. I'll jump back into the rest of mine. And thanks everyone for being patient with the proceedings. I know it's been a long time. Are you aware of any venue in close proximity that are open beyond 2 a.m. Monday, Tuesday evenings? Out of curiosity. Is it open on Monday, Tuesdays after 2?
So 7 days a week till 3 a.m. And they have a large list of extended days until 4 a.m., which is the biggest list I've ever seen. Obviously Blue Fly, no, it's not Blue Fly, is it? Drawing Board is open till 4:30, 7 days a week.
The takeaway and London.
Yeah, and then we also opposite have Chico's Takeaway, which is open. I don't know what the time that is.
Provisional late night refreshment license.
Yeah, it's provisional late night.
Later than 11.
And it's very late. It's all, you walk past it at 3:30 in the morning, it's open. And similarly is Londis on the bridge as well. That's got virtually a 24-hour license. It may shut from 4:30 till 6 a.m. or something, but it's not far off being a 24-hour license.
I think alcohol sales at Londis stop at 4 and they resume at 7 a.m.
Thank you. Why off-premises alcohol sales? As this page 64 in terms of the application page. But yeah, why not just on-premises alcohol sales?
Pavement cafe.
As you probably heard there was a misunderstanding about the pavement licensing regime. So the reality is there'll be no off-sale, so you can amend that. The pavement license can be amended and applied for in due course for the rear up until 10 p.m.
So we're happy for that to be on premises only for now if we condition that. Again, it depends on whether we feel that's necessary. Well, why 3 a.m. Insufficient on days like Christmas Eve or some of the other dates that are kind of one-offs? If they do fall on a Tuesday evening or whatever.
I think, as you've just heard, it's about trying to be all things to all people, and it's just about trying to get the maximum scope and flexibility. I mean, the reality is, if this premises were granted a license, it will, as it has had experience of operating 10s until 11, until 2 and until 4. For special events, it will attract a crowd, and that will be great. But for a regular event, perhaps if they were to do a student night or a cabaret night, a student night might only last until 1:30, 2 o'clock. A cabaret night might finish sooner, especially if it's during the week. What the venue wants to do is just give itself a full range of flexibility and options. And I think that's partly been formed by that flexibility. And secondly, by why can't we have it too? So that really touches to this kind of sense of exclusion that is felt by certain sectors of the community, not necessarily all the community.
Sure. looking at the Little J programme and some of the things that are marked as kind of late night, Moral Panic, Ginger Slice, Halloween, Roxy Rider Cabaret, Talk with Photos, The Queer Britain in the 90s, Generate Fundraiser, etc. And the temporary event notice, we don't have it in any of the papers, the list of what temporary event notice happened, but I'm aware they're not all 4 a.m. So are you able to indicate which ones of those in the past have run till what times?
Yeah.
I know the calendar says late night, but I think some of them were a lot earlier when they have run in the past.
I think on the 7th of July, which was Saturday, that was the Pride event, 4 p.m. to 4 a.m. On the 27th of July, there was the trans non-binary open mic night. That was 4 p.m. to 2 a.m. Similarly, Ebor was 4 a.m. to 2 a.m. And on the 25th of September, the application was until 2 a.m. I think that's the one that police made objections to, and it was reduced to 11 p.m. Public protection, sorry, public protection. And then the one for Halloween, where the police objected and they'd explained why, I was the person that advised to withdraw it. I just thought it would probably be easier to have this conversation before the premises continued with its 10s. So you've got 11, 2 and 4, which I think are the times I mentioned.
So most events are at 11 p.m. Both pre and post licensing, and then
one is at 11 p.m. 2 have been 2 a.m. and 1 have been 4 a.m.
Can I just add a correction on there? It was a 2 a.m. 10s, but the regulated entertainment was restricted to 11. And that was because we were doing the noise impact assessment, but it was for 2 a.m. for alcohol. And on the advice of Michael, after 11, we went to background.
There was alcohol until 2, thank you.
Yeah.
I'm just, I guess, following on from that, what your feelings would be if hours granted were more like 2 a.m. or something, more like those compared to what you have applied for, given that's what has been running in the past.
That would be very much, I mean, it's your decision.
Of course.
Yes, it's your decision. We are requesting the hours that we've requested. And make that application strongly. But I do understand there are other factors that need to be considered by the licensing subcommittee.
Thank you. And last one from me, but it's obviously a fairly significant one. I appreciate you called it tittle tattle. They called it wholly unsuitable in terms of the designated premises supervisor question. And I guess my questions on that are, does the applicant believe they were reasonable in all of the email exchanges and the engagement with the temporary event notices? And does the applicant agree that there were some untruths regarding the applications in what was said publicly?
I think there's so much passion. I just think, I think this is why it's so inappropriate to go sort of stirring through the sort of private emails of jilted parties. Hopefully we can move on from this. But the reality is there is real passions that are engaged. People are coming at it from different perspectives. And rather than what people say to each other, I think it's more interesting to observe, the actions. And the fact is the police say, well, we don't have any issues. The fact is, under the sort of unsuitability of Graham, under his mendacious conduct, he's able to operate 10s, he's able to engage, he's able to instruct experts, he's able to sort of have Halloween and parties and so on, and has been a sort of really valued member of his community to the extent that all these people turn up to support him. So I utterly turn my face against what the police say. I think it's wrong. I think it's inappropriate. It refers to a legal regime that has been put to one side. Fit and proper person, as you know, is a legal test from the 1964 Act, which was repealed over 20 years ago now. So they're using the wrong vocabulary. And rather than looking at the effect of operation, they're focusing on personality. And that's just really quite uncomfortable, and perhaps the only fly in the ointment of what is otherwise a very sort of sound and open-minded presentation by the police. So we don't accept it.
I appreciate that point. And from a venue perspective, going into anything personal is obviously irrelevant. For the designated premises supervisor, it is inherently personal, I guess, to some extent. And people do get heated. It's obviously a really important and passion-driven proposal, endeavour. I just guess, from my perspective, part of that being the reasonable person is understanding when you might have crossed the boundary and then acknowledging that and stepping away from that. And I just wanted to see if there was any thought of where that perhaps exceeded a line.
I mean, if it helps, on listening to the police representatives, Graham did whisper to me, "Oh, they're really quite nice, aren't they?" I thought, "Well, yes, actually, Graham, they are." But the point is, Graham has the lease of the premises. He is one of the company directors. He will be employing the general manager. So actually putting a police hat on, if I want to prove their sort of personality attack, then having him firmly in their crosshairs as premises license holder and DPS is actually a far more sensible way to move forward, because if anything, and I will say this in public and in private, maintaining good relations with all the responsible authorities, and as you say, sir, knowing when one's passions have crossed the line might be an important thing to observe, but maintaining good relationships with what are very helpful and well-informed officers from the police and public protection is really important for the promotion of the licensing objectives, and that's been demonstrated today. So I'm certainly hopeful that we've got a real reset here, whatever decision you and your colleagues might want to make.
Thanks. I won't take more time going around the house. I know you said that the lawyers are happy to tread on toes and nobody else is. I am happy to tread on toes. There's a little bit of legalese there, and focusing on whether you agree with their opinion about the DPS rather than some of the private papers containing some relatively serious accusations and some of the stuff that was said publicly that may or may not be accurate, which was the nature of the question I was asking. But we'll move on. Any final questions from us before we revert back?
Yeah, I don't want to move from that point, because as Councillor said, you talked a lot. There has to show, everyone's been nice, but what was said, we can't deny, was in the papers. Therefore, there was no acknowledgement that they went too far. You're still arguing that, I don't know what you're arguing, but you're not arguing they either felt regret now or no regret now. It's a simple question.
It's not the forum. I don't see how it's relevant. Okay.
It's fine. We can move on. And sorry, Sandra, for taking a rather significant detour when I went to you first time there. But if we can go to your 15 minutes now, that would be great. Thank you.
Thank you, Chair. I have, in fact, you'll be pleased to hear, taken the opportunity to edit my notes so as not to be repetitive. On behalf, these are my submissions now on behalf of the licensing authorities objector. I refer you to the licensing officer's submission, which of course you have. I don't mean to repeat it all. And I would just also start by saying that the licensing officer has instructed me that she agrees with all of the submissions that have been made here today by the police regarding the lack of engagement from the applicant. So this application, as currently formulated, would enable, if granted, would enable essentially a vertical drinking establishment in the CIA, which would drive a coach and horses through the council's licensing policy. With respect to alcohol-led venues such as this proposal, there is, as you know, a strong policy presumption against the grant of a licence. Although the applicant has offered some conditions relating to the provision of door supervisors and the prevention of public nuisance and age policy, etc., which are all welcomed, the applicant has not made any adequate attempt to address the CI policy in the application as formulated, and it is not considered sufficiently robust as currently formulated for a premises located within the CIA. There's no kitchen on site, so the premises cannot be food-led. Tables and chairs are removable, so the premises could offer vertical drinking. There is no offer of a set number of seat covers within the operating schedule, nor is there an offer of table service. I've already made the point that an application within the CIA requires a particularly robust operating schedule. to demonstrate particular measures at the premises to address the likely impact of the availability of alcohol and other regulated entertainment in an area that already experiences a high volume of antisocial and criminal behaviour and public nuisance. These, of course, all being the factors behind the creation of the cumulative impact area in the first place. The nature of the problems within the cumulative impact area is that they are cumulative rather than attributable to any specific or individual licensed premises. The high number of premises within the cumulative impact area means that even a small change in the area can contribute to the cumulative problems already being experienced. On that basis, the licensing authority has made its formal representation. Notwithstanding the nature of the application as a community venue, which is supported by the licensing authority, the licensing objectives should be key considerations at all times, and the subcommittee in my submission has to consider the reasons for the cumulative impact policy and what is the likely impact of granting this application on the CIA and the promotion of the licensing objectives. Of course, the subcommittee has to rely upon the evidence given by the police and attach the necessary weight in accordance with the Section 182 guidance, the police being your experts on crime and disorder and policing. And public protection, who are the experts on public nuisance, also consider that there would be issues with public nuisance as matters currently stand, as you have heard. The licensing authority are the gatekeepers on policy, and as such cannot support this application in its current form, as it is within the CIA and does not demonstrate through a sufficiently robust operating schedule or conditions offered how it will not add to the cumulative impact already being experienced, and how it will not undermine the licensing objectives in this already saturated area. The CIA policy needs to be applied fairly to all operators within the CIA. The paramount issue for determination is ultimately a simple one, in my view. Has the applicant successfully demonstrated that the premises will not add to the negative cumulative impact of one or more of the licensing objectives? Thank you, Chair.
Thank you. Well within time. Again, going through the same order as usual. Applicant, any questions for licensing authority?
It's just unclear to me, are the licensing authority treating this as a vertical drinking establishment or, as you say, a community venue which is accepted? Because of course the effects from different types of venues are different. Which is it? You can't really have both, can you?
Well, I think it can be both, because, well, there is no designation, as you know, in licensing laws, a community venue. But as applied for, this premises could operate as a vertical establishment bar or nightclub.
So you've not given any consideration to condition 1 agreed with the police or the description in the operating schedule that describes this as a community venue, which is one that it's music, performance and art led.
Sorry, I didn't catch the start of your question because I was taking some steps. Sorry, would you repeat the question?
You've not given consideration to the fact that we've agreed condition 1 with the police, which is that we would operate as a community venue, and we described our premises in our operating schedule as a community events venue with music, arts and performance.
Well, as I've said, there is no designation of community venue. It doesn't mean anything in licensing terms. So the fact that it may be a community venue would not prevent it from operating as a vertical drinking establishment.
But no, the conditions do, don't they?
No, they don't.
No,
There were
okay,
no
you
conditions
think
that would prevent a vertical drinking establishment.
And in terms of being gatekeeper of policy, why are you only focusing on one aspect of your policy and not, for example, looking at your vision, which is about making the city centre safe and welcoming and accessible to all? Why aren't you focusing on your equality policy, which is also in your SLP, and the need for diversity? I mean, those are key policy considerations as well. Why has licensing ignored equalities, accessibility, and diversification of offering?
They have not ignored any of those things. They say that they do not oppose, they would not oppose an application which had a sufficiently robust operating schedule in the same way as any other operator in the area would be expected to have a robust operating schedule. Whilst the PSCD is of course a relevant consideration, the key consideration is whether the granting the application would have a negative effect on the CIA. And this is ultimately the overriding factor and test for the subcommittee to consider.
So maybe my colleague hasn't understood the question. There is more to this policy than cumulative impact. There are other policy considerations. Perhaps it might be useful to go through them because I don't know. Do you have the policy with you, you or your officer?
The equality, the council.
Shall I finish my question?
Sorry.
Yep. Do you have the policy with you? Okay.
Which policy are you referring to?
Your statement of licensing policy.
Yes, I have it here.
Okay. So paragraph 4.4, sir, sets out a vision for the local authority, which is an entirely lawful consideration, isn't it?
Yes.
Yeah. And in fact, it's one of the key aims and objects under paragraph 1.5 of the section 182 guidance.
Yes.
Yes. And one of these visions, which is a policy consideration, just as important as CIA, is to have a safe city centre which is welcoming and accessible to all. That is a standalone aspect of the policy, isn't it?
It is.
It is. So that's unrelated entirely to cumulative impact.
It is unrelated.
Yes, thank you. So that's one policy strand. There is another policy strand, which is paragraph 4.29, that the council must have regard to its public sector equality duty under the Equality Act 2010.
Yes, the decision maker should have regard. Should have due regard. But it is not the overriding consideration.
There is also paragraph 6.4. The council would like to separately address in its policy diversity. That's diversity of offering, which is a mix of different types of licensed premises, particularly in areas where there is a high density of such premises. Diversity will attract a broader range of customers from local residents and visitors, giving greater choice for different age groups, and it gives potential for positively changing and improving the ambience of a city. This in turn may have a positive effect, increasing the numbers of evening visitors to the city centre while improving safety and reducing nuisance and crime and disorder. That's a further standalone policy, isn't it?
It is one of the policies.
Well, now under that policy, how many, well, you know, it's quite clear that licensing authority haven't read or understood their policy, so it's important to get to the bottom of this. And now under that policy, having a community arts and music performance space that caters to the LGBTQ plus community where there is none directly addresses that policy in isolation, doesn't it?
The licensing authority do not object to a community venue. It is the location in the CIA which triggers the cumulative impact policy, which requires a robust operating schedule, which has not to date been offered by the applicant.
So I won't ask any further question. It's quite clear that there is another aspect of policy which is triggered, that is diversity. This application triggers paragraph 6.4.
We're in clarifying questions, of course.
The licensing authority are refusing to recognise that there are other aspects of policy that are just as relevant to cumulative impact, and they are slavishly fetishising the cumulative impact and closing their mind to other aspects of the policy, which makes their evidence and submissions entirely unreliable. And that's an important.
I'd like to clarify the purpose of this
you.
section is for clarifying questions to the representatives. Obviously, you've got closing comments to make any further points on that as well.
Thank you.
We'll go through the rest in order. So police, any questions?
No.
Again, awkwardly, public protection got any questions for the licensing applicant?
Okay.
And then in order, I've lost my list of people. Joe and Phil. Leo again, I guess. Andrew?
No questions.
Now Big B. And Jake. And members.
Come on.
The fact that the applicant has agreed to work with the police with the schedule of community events and work out the appropriate actions according to each event, would that be a mitigation factor reflecting the fact that there is the various different events that need different levels of security? I suppose is the word.
Has that actually come out that that's going to be a condition on the licence, that a diary of events will be submitted? We would need to know when, the level of information on that diary. A query I have at the moment is it says events will go on till late. We would need I guess that's licence dependent where they haven't put the end date. But if that went on as a condition and those events stated clearly what was happening at those events. So, for example, the condition that's been discussed about the SIA only being present when alcohol is being sold, that would be very important on that diary of events, because otherwise it would be really difficult to assess when SIA should be present or not. So from an enforceability standpoint, it becomes very difficult to know whether SIA door staff should be present or not. So yes, that diary of events would help, but it needs to cover key information.
Thank you.
Okay.
Got a few for you. I guess the first is picking up on the back of the questions from the applicant, and I accepted slightly more, I guess, implied hostility than I would probably accept if it was a representative being asked those questions. But because you know, the lawyers can take it. But that question around the Equalities Act weighting against the other policies we've got here, my understanding of what you're saying is that there is no objection on grounds other than for the cumulative impact assessment, though, that there wasn't any other policy area where there was concern, but that wasn't saying that you know, the Equalities Act doesn't play a part in this. What's your thinking about that weighting of the challenges to the cumulative impact area versus the Equalities Act and other policies?
Chair, of course, the public sector equality duty is a relevant consideration. It is for the panel to decide how much weight to give it. The duty, of course, is to have due regard. There is no duty to bring about a particular outcome, you will no doubt be advised on this by your legal advisor. So there is total acceptance that the PSCD is a relevant consideration. My submission is that it is not the overriding consideration. And I refute the suggestion that the licensing authority, in making its submission, has not understood its own policy.
Thank you. And it's kind of implied in the questions as well, but that police condition 1, use of it as an LGBTQIA plus community events, venue and bar, does that impact the concern you have around the vertical drinking? Does that limit it appropriately in your mind?
Well, Chair, what does it mean? It doesn't prevent a vertical drinking establishment or a nightclub.
I guess the fact that it suggests that it's a community events venue and bar, if it was solely used for vertical drinking, that wouldn't make it a community events venue.
It doesn't prevent it being a vertical drinking establishment or a nightclub. In fact, there are removable chairs.
Is there anything in your mind condition-wise that could be applied that would appropriately, you know, change or add a condition to that would make it more consistent? It sounds like the applicant wants this to clearly be a community events venue and bar and not a vertical drinking establishment. Is there a way of us, you know, satisfying the authority on that?
So we would normally look to our experts, who are the police, in matters such as these. To prevent vertical drinking, normally the police would suggest a minimum number of seats. So if you were looking to combat the vertical drinking element, then certainly a condition could be put forward with a minimum number of seats when perhaps alcohol is being sold. That's just a suggestion completely off the top of my head. But we would normally not come up with those sorts of conditions. We would look to our colleagues in the police. So it might be worth coming back.
Yeah, we can return to that after closing statements in general questions and conditions at that point. But that's useful. Thank you. And then the last thing from me is also there are two more. The door staff 10 p.m. versus 7 p.m. versus alcohol or non-alcohol. obviously in the paper we've got a whole bunch of other suggestions at various points during that sort of pseudo negotiation bit around sometimes maybe one based on a risk assessment or different types of event. Well, what's your take as an authority on where and when that's appropriate?
Again, I would completely defer to the experts in the matter. The experts in the room are the police. Crime and disorder falls within them. Personally, door staff are not just there to protect the venue, to prevent people coming into the venue that they don't want to come into the venue. They are also there to protect the people within the venue. So there are instances where I can see that condition would need consideration with what the police have already asked for.
Thank you. I'm just trying to find the page because I didn't write down a page number. Yeah, it says so in the specific one-off days that are in addition to the weekdays, Pride event is one of them. I just wanted to clarify from the licensing authority's perspective in terms of wording of that. Pride can be a month, it can be multiple sets of events around the date. I'm guessing this implies on the day of the parade in the evening, that Saturday night or whatever, but is there wording that we would need to put around the condition to satisfy the authority around what Pride event specifically means?
We'd possibly have to ask the applicant whether they just meant the Pride evening, or did they mean the lead up to Pride, Pride week, Pride month? We'd maybe need some clarification on that.
That's fine. And the last bit is this broader question of the designated premises supervisor. There was no objection, there was no reference to it in the licensing authority. It has come quite late in the day. We're talking about things that have been final, 11th hour stuff as a level of concern. What's your take on that situation?
Again, in the Licensing Act, and I think Leo will completely agree with me here, it is not for the licensing authority to object to a designated premises supervisor. If there was an issue with somebody being a designated premises supervisor, it would come from the police from a crime and disorder stance. So I would never have an opinion as the licensing authority as to whether a designated premises supervisor was appropriate.
Thank you. Any final questions from our side? No. Thank you very much. We'll go into the 5 representatives and we'll go through in the order that we've been going in. This is the first representative has up to 15 minutes, York LGBT Forum. Thank you.
Thank you. I am one of the trustees from York LGBT Forum. So I just wanted to reflect from our point of view the community need for a safe space for the LGBTQ community, which they can access safely and equitably in York. As others have mentioned, there are nightclubs, bars and other spaces available generally in York, but to have a venue where the community themselves feels safe is really paramount, particularly with regards to, firstly, the rich and valuable cultural contribution the community makes to York, but also because of the discrimination and hate crime which is currently on the rise, which the community faces, and which many of our members, the York LGBT Forum as a charity, many of the members have had that experience, and we exist to support them with regards to that. We also really value and welcome any dialogue about creating that safe space and continuing to have that safe space available, and to be able to at the same time work with colleagues in the police, with the council, to address issues such as hate crime and discrimination. So that was just what I would like to say on behalf of the York LGBT Forum. Very happy to continue any conversations with others. Thank you. Phil.
So I'm Phil Grossitz. Oh, sorry, I'm Phil Grossitz. I'm a volunteer and support group facilitator with the York LGBT Forum. So in this role, I co-run a peer support group for trans and non-binary people in the York area and wider. I've seen it firsthand, the worsening situation nationally and locally, particularly for trans and non-binary people. Many of the people I support have expressed an increase in anxiety doing day-to-day activities. Reported hate crime is the tip of the iceberg, and low-level harassment or worse is a daily reality for many. there are limited places for LGBTQ people to socialise and find community at the same time as an increased need. I'm not going to dwell too much on that point, because I think it's fairly well, discussed and established. So I'd like to speak in favour of Little J's licence application and the vital role it can play in providing a thriving and safe space for queer people in York and the wider area. I've got no conflict of interest. I don't take any. I put on shows and things. I'm a performer, but I don't take any payment for those. So I don't have any sort of financial interest. So I'm a musician and performer and co-founder of Moral Panic, which is a monthly inclusive cabaret open mic at Little J's. So I've known Graham since the start of the year, January, February, when I started visiting the site during the renovation. So I got to learn a lot about Graham's desire to create a space which would combine the role of venue and community space. So I've been personally struck by his hard work, his enthusiasm for what's clearly a passion project. I've always found Graham to be extremely community-minded, dedicated, easy to work with. It's very noteworthy how much time he spent reaching out to other people in the community, to canvass opinions, to attend other people's events and create those bridges and networks with people. He's gone above and beyond to ensure that community events go well, often by dipping into his own pocket. Little J's is not a charity, though, and without the opportunity for some commercial activity, I fear these community events will be at risk. There are many examples of these community activities in the supporting documents, and Bigby will talk about Stubborn Roots, the trans and non-binary folk group, but a few more examples include an excellent pay-as-you-feel theatre show written and performed by Stevie Hook, which highlighted trans experiences in a funny, thought-provoking way, numerous coffee and crafting social events, for example, run by Ginger Slice, free rehearsal space for a number of local performers, free style workshops. So I'll talk a bit more about the Moral Panic events. So it's the only queer open mic event of its type in York. So LGBTQ performers have been able to perform in a safe space to a supportive audience. We've had original music, dance, poetry, demonstration of self-built instruments, inspirational storytelling, drag, comedy. Many people have never performed before or would not feel comfortable in a regular venue. So these events welcome all, and allies always make up a good number of the audience and performers. And I think it's really important to all of us that this enhances community cohesion and encourages mutual respect. So a version of this event ran for 2 years at the Portal Bookshop in York, which is a great establishment, but there was real issues with lack of space, lack of accessibility, lack of toilet facilities, which caused it eventually to end, because we didn't have a suitable space. So under Graham's management, Little J's has allowed a fully inclusive and accessible event on a much bigger scale. So I'm proud to be part of an event where the queer community and allies can support each other. There are many performer and audience comments in the supporting documents, but I'll just mention a few. So this is an example of Ruby, who's an ally, and she writes, "Of all the open mics I've been to so far in York, I felt the greatest sense of safety and acceptance at Moral Panic. The sense of community at Moral Panic was obvious, and I think Little J's represents a space where we can support each other and feel hopeful about the future." Daniela, who's an event attendee, says, "Attending Moral Panic enables me to enjoy a night of entertainment in a safe and welcoming space. As a neurodivergent person, I found it to be extremely inclusive and accessible." And other people talk at length about Little J's as a safe haven or as a place where they can finally belong. Now, I feel like I'm pushing an open door. I feel like a lot of people here will support those activities and that intent. And I just hope it comes across as how important those are to our community. But I do want to emphasise it's not easy to create such an inclusive and welcoming space from a standing start. You don't just open the doors and that's it. So this is a real testament to Graham's vision and his willingness to give other people opportunities. So it does come down to personality and setting an ethos and a culture. It's really important to support this venture as it's still in the early days. It can really flourish. And I really believe it can put York on the cultural map in the wider area. But you might ask, which is why we're here, why is it so important to have a licence? And non-licensable events will always be important. So coffee afternoons or like we did a Halloween event, which was a dry event. Fine. And it was very well attended. However, it is also vital to be able to put on some evening events on the same basis as other theatres or night venues. Alcohol is not the main focus, the same as it isn't if you go to the theatre or see a show. However, live and recorded music and performance is a vital part of providing a venue which provides a safe and supportive evening space for queer people and their allies. So I sincerely hope that the council will grant Little J's a licence on the same terms as similar spaces without lots of heavy restrictions. And I appreciate the subtle and open back and forth that there's been today. I'd like to add that I've had a number of conversations with local police who have discreetly dropped in during events I've been involved with. It's probably on 2 or 3 occasions at least. They've always been very friendly and courteous, and I've welcomed their support. I think they've shown a good example of what community policing is. They've turned up supportive, open, and actually we've just been able to have a good conversation. So I genuinely feel on the ground, both people in the venue and community policing, I think it's actually worked pretty well. And I would hope that I don't see any reason why that wouldn't continue. But I just want to put it on record that I've noticed, and personally, I've appreciated that. I genuinely feel there's a route to satisfying any needs for safety and public order at the same time as supporting a much needed fledgling venue in the city. Without Graham, his investment, hard work and passion, it would not exist. It would be a tragedy to lose it. So I hope you'll consider the application positively, and I'm happy to answer any questions that people might have.
Thank you very much. I guess questions starting with the applicant, 5 minutes. Okay. Police, public protection, licensing authority, and then Leo again. Andrew, Bigby, Jake.
No questions. Thank
Members. I have one question.
Okay.
2 questions. The first one is actually, I can't find the page in here, but there was a reference to how the Portal bookshop had ended up having a challenge with the police, which we haven't actually discussed at any point here. But did you guys have any experiences at all while you were engaged at Portal with?
I don't know. I don't know anything about it. We had no issues running our event there, apart from the things to do with accessibility. It's a great place, and it's in the terms that it currently runs as a bookshop and coffee shop. It's a great establishment, but it's incredibly small. You can barely fit more than about 10 people in the venue. So that was practical reasons only was the reason we stopped doing it there.
Thank you.
We did try and find other venues and we weren't successful. So.
And we had some comments there around how, for example, the venue that's referenced in London doesn't actually have a license. Obviously, this has been operating without a license with temporary event notices. It can do up till 11 p.m. without alcohol, but the timings here are 7 a.m. to 3:30 to 4:30 a.m. fully open. The possibility for the licensing could be 11 p.m. alcohol sales and 2 a.m. Saturdays and nothing beyond that. And what are your thoughts around the extent to which these extended hours are necessary for the various events and activities that the LGBT Forum and community are seeking in York?
I think we've been happy trying to doing a mix of things, because some people in the community do really have a need or appreciate doing events which are dry, and I've no problem. The events at the Portal Bookshop used to be dry events, and so no problem in principle with doing that, except so it's just to say that in addition, I think we need the same right as anybody else is to put on events which do serve alcohol, and I'm mindful as well of that the venue needs to be financially viable. It's not a charity. It doesn't require grants or any other money to keep it going, so it needs a fair crack to be able to make some kind of return, to be able to justify opening, and also to justify all of the free stuff that's been ongoing. So all of the community stuff that's happening is all free of charge, no room hire, no restrictions whatsoever. It's just a case of, oh, you want to use the space, that's great, off you go. And so I'm mindful that part of the license is allowing it to cross-subsidize the free stuff that happens.
Thank you very much. we'll go to the second representative then, up to 15 minutes. It's Wayne Dawson of Queer Arts CIC, and again, I guess it's Leo Charalambides who's got 15 minutes.
No, I've got it wrong.
I'm Bigby Ellis-Watson. I've been a volunteer. I'm a member of Queer Arts, but I don't. No, it's Generate, isn't it? Have we been asked for Queer Arts?
It's Queer Arts represented by Leo, and then we've got Bigby Generate, the fourth representative. Yeah, no, it's okay. We've obviously had a bunch of movement of who's representing in which way, so we can take a moment to make sure that we've got everybody covered in the right order. If there isn't anything specific to present on behalf
So no,
of
the representation on page 109, I'm quite certain you've read all the representations. Thank you.
Yeah, and I guess we'd still have the questions off the back of that. If there's anybody, I don't know to what extent you feel comfortable answering questions, but we'll go through the rounds. Questions from the applicant for the representative, police, public protection, licensing authority, Joe and Phil, Andrew, Bigby, Jake. Councillors, any questions on that one? No. Okay, we'll move straight to the third representative then, which is Andrew Malcolm Neal. 15 minutes.
Don't talk too much. Right. Hi, I'm Andrew. I am last season's captain of the York RI Templars, which is a men's plus rugby team in York. I'm going to do my best to stay in my lane today, and only speak as someone who has tried to organise gay bi trans group in this inclusive community. So first, I just want to say it's very pleasing to hear the general support. Just echo this thought. There's good support in this room for a project. It jars in the best way the tenor of what I was reading this week, so that's good. If it helps, I live in the cumulative impact zone, which is something I opted to do, and I notice it covers kind of everywhere that isn't actually residential in this city. But anyway, I think it's it's an important part of town to be represented as a community. So I'm going to speak to represent briefly and in descending order my experience last year coordinating between the groups you see here. There was a kind of a group of us that got together to try and do things together, and how that would have benefited from the Little J space. Talk about my own experience leading York's gay bi trans rugby team as an exemplar of a community group looking for the space, and how that would have been helpful. And a note at the end about my own experience as a queer man in York, and how Little J sort of helped with that. My hope is it will be a useful illustration to emphasize the outsized impact on our community and public safety of this project, a dedicated community space, and to illustrate hopefully our experience of disorder and nuisance as something that we navigate, not something we cause. The short version being, without an organizing center, it has been historically impossible to have an accessible community in the city. Without a venue that can attract the whole community, it has been hard for us as an LGBT group internally to bring in new people, and externally to be able to advertise to attract visitors to our city compared to our competitors around the north. And as a dedicated space, it can be a refuge for the most vulnerable people, of course, but it also gives a freedom to everyone in the queer community in a way that no sort of generically inclusive other venue ever can hope to replicate. So to speak on the experience trying to get gays to work together, in the absence of any kind of focal point, it's pretty much only this year that we've started coordinating and found each other. And it's recently and haphazardly that we started this idea of mutual support and building our coherent sense of community. I say that to emphasize that the average LGBTQ plus resident experience of York is a community that is very siloed. We have our rugby team, they have their arts project, blah, blah, blah. There's no space where it all comes together. And it's entirely natural then that if you were to build such a space, it would not simply be a church hall. It might aim to do a little bit more than that. And the organizing center of the LGBT community has always been the events it holds. So to pretend otherwise, to treat this space differently to those other venues around the country would be to uniquely hold down our community, I feel. Contrary to a comment that was made earlier, I wouldn't agree that York is that successful. We've had the closure of many performance venues. We've had gay nights that didn't really get people together. We've had bars with pride flags. We've had gay managers. We've had bars owned by gay people. And none of them was able to facilitate the need that I'm describing to get everyone together, to be coherent, to have a space that we can all rally around and focus on. It has to be a dedicated, it has to be a user-facing space, such as the one proposed here. And the evidence is that these are exceedingly rare in York, especially. Certainly ones that are interested in being so open to everyone across our community and used for multiple purposes. So I really do, I feel very strongly that this project is unique. It's the chance to get things going for us as a chance to build a safe and thriving public community and to operate in a way that reaches everyone. It's clearly going to need the flexibility that a license offers. So my experience running this rugby team. So York RI Templars are a gay, bi, trans inclusive rugby team. The first issue to note is it's bloody difficult to recruit people. We have a very disparate community in this city. So we basically rely on word of mouth and luck. And as such, we have stayed very small, as have many other groups in York. There's nowhere except Pride, I guess, where we can show up and reasonably hope that our advertising will convert into players who are new to rugby coming down to training Monday nights at 7, find us on Instagram. And when we play in a league, we play against similar teams, and that kind of shakes out that there's one team per city, basically. One team per city means there's a lot of travel involved, which means that your away matches become a relatively big deal. And we're talking about, we travel to Manchester, Liverpool, Preston, Hull, Sheffield, these places. I hope I haven't left anyone out. And we connect to the people through the place and through the scenes in those places. The LGBT scene in those places. So how does York compare? We've been in the league for 4 years now, and we've never had a team stay over with us. My point being that an LGBT venue is a place of convergence for lots of people. It's a hook for people, including potential visitors to our city. It's a marker of our welcome to them. And they read into its absence as much as they would read into its presence. This venue has already hosted a bunch of events. Those immediately attracted interest, including players from my team who are very excited to be there and meet the wider community of York, which they would not otherwise have an opportunity to do. And the people who've missed it have been trying to get in ever since. So everyone is crying out for this kind of a place, and it's not hard to understand why. There's a freedom in dedicated venues that nowhere else can provide. We all know, at least on this side of the aisle, that bouncers and punters in other venues are not always predictable. And for a away team, that's even less in a strange town. There are horror stories all over the place. So that's I've written a note to myself here. That's before you consider trying to get a team's worth of men into a venue that doesn't know they're coming. But the point of that being that the legacy of other people's, other rugby teams, other people's nuisance behaviors in those generic spaces mean that I can't, as an organizer within York, compete with other people around the country in the offering that they expect, the experience they expect in our city, which is a place that we could gather beyond the rugby pitch itself. That actually got me thinking, how do we compare? So I borrowed Work's ProChat-GPT and then checked all the venues it identified and asked it to compare all the cities in the north of England. And of the 18 cities it could find, only Ripon and Chester don't have anywhere at all to go, don't have anywhere nearby. So Salford, Sunderland, Bradford, Carlisle, all of those, they've got at least one. Obviously, Newcastle, Manchester, they've all got places to go. They are way ahead in recognizing the outsized value of a dedicated space. We are far behind. I also asked it to ask Europe. So 31 York-sized cities, the ratio is 5-1 having some kind of discoverable, dedicated LGBTQ plus venue, and we are apart from them and we are behind them in this city. So for our city to provide a competitive, safe offer to our visitors, we're going to have a dedicated venue, and that venue needs a license. Lastly, my own story. So I kind of get by without people assuming things about my sexuality. So I tend not to be so much at risk in the rest of the world in city centre, unless I do something visible, like, hold my boyfriend's hand or kiss him in any way, then it's edgy and harassment follows. But I also experience that kind of relief and joy of being in that dedicated venue. You don't have to be in the kind of emergency hate crime situation to experience an incredible difference of space and the liberation that comes with that and the change that in your behavior. And we see that all the time when we go out. And obviously, when I say that, I mean, we go out in other cities because you can't do that here. So even if we solve for hate crime, we also still have a demand for a space of this kind that provides a coming together and a safety. So for the unique joy of meeting your friends and being temporarily in a safe majority, I also think this place needs a license. I was reading the papers this week. I expected some gay drama from this project, but there's a lot of resistance. It seemed, we had a great conversation today that seems to make that more detailed and less principled, so that's good. The campaigning has been bruising, but I'm sure survivable. But the objections seem to ring hollow to me, at least as an outsider, compared to the experience of LGBT groups at big public events. I note that Pride is a huge alcoholic event. And all we ever hear from the police is that they aren't allowed to smile anymore, but they love doing it because it's easy to police. And compare that to, I imagine, all of our experience of the behavior at any number of other York venues and other York groups. It seems very hard to substantiate this idea to me that there is a noticeable, accountable threat of nuisance from this community, especially given the enthusiasm we've seen from all sides of the table today. So I believe what I see. I've been to a range of events, licensed and not, at this venue, including the fabulous Pride Night that Graham has operated in a great atmosphere for everybody there, I dare say for the people outside too. And that seems to me to say that the temporary events have passed a real world test by the applicant of low impact, and they passed it with flying colours. So my summary is, in front of us, there is what we know to be a rare opportunity to meet a community need that is well understood in every other city, but York has failed to meet for the longest time. It does not seem to me to serve anyone to say that you will support at some other imaginary time, some other imaginary location, some other imaginary owners. We have been waiting forever, and we have tried smaller versions of this and smaller projects, and they all fail to have the effect that we need to build something cumulative and community-based here. The place has to be licensed to work. It would not credibly be of interest to a plurality of the LGBTQ+ community otherwise, and that must be of interest to serve our community. So if we can't make even this pretty small venue pretty out of the way, but open to all comers and all kinds of event, I really don't see how York will make any kind of claim to being a place that has a supported and safe, coherent LGBT community. So I'm urging everyone here to kind of thrash out the details, which seems to be where we've got to, so that we can build something, I hope, genuinely game-changing for York. And so, yeah, just to repeat the summary, because I am tired of living in the only city mocked on our tour for its lack of queer culture, and I want to dance with whoever I want to without looking over my shoulder, because as a queer-centered rugby team organization, we need a place our friends can come to, that we can host events as a city and advertise ourselves as a team to this city, and because to support ourselves as a community that's tried to organize together to tackle isolation of people, drive creativity, we need a focal point where people can actually find us. So for all those reasons, I would urge the granting of the permanent license for Little J's.
Thank you. 1 second.
Yeah, thank you, Chair. If I can just come in for one moment. I just want to re-emphasise the point that was made at the speaker's initial at the commencement of what he was saying. He said he was last year's captain and was only speaking as someone who organises groups for the LGBT community. I'd ask that you have that in mind, because we have had an email through from the rugby club saying that it's not representation on their behalf. So just go back to that point that the speaker is last year's captain, organising groups for the LGBT community.
Yeah, this is my voice, not the club's voice.
Yes, fully understood. Thank you very much. All right, questions up to 5 minutes, and we'll go around the same order as before. So applicant first. Police. Licensing authority. Public protection. Jonathan. Wayne. And Bigby. Jake. Councillors. And the same question from me as before, looking at the hours of operation and the ability to operate. So you talked about how it's important that we have a fully licensed venue as opposed to an unlicensed venue that can do one-off events. In terms of those hours, the difference between, an alcohol sale that can end at 11, those late night events, the difference between, going out on a Monday night and expectations around that versus, Saturday night and Pride. Obviously, the application here is 7 a.m. to 3:30 for half the week until 4:30 half the week. What's your take on that from a participant and event organizer?
Yeah, so as if I've understood correctly, listening along, the idea is meant to be that this is a flexibility, so it's an option that can be exercised. For us, I think it does make a huge difference. You can imagine there are times when we would want to use the space as the space as community centre, as a place we could have meetings as a team, the place we could have recruitment events, things of that sort, where there'd be no need for anything particularly interesting to happen. There are other times when we would celebrate big events. There might be big whatever international rugby events we want to gather people together to watch. We might have our own celebrations of we've played a particularly good match. That would be an evening thing. There'll be big whole community events that then it would be good to be able to have an ability to go late for those, just as a way of getting everyone together and say converging and celebrating there. So yeah, I think the flexibility is the key thing, to have the options for these events. But yeah, very unlikely to promote drinking till 4 every night as captain of a rugby team. It's not considered best practice.
Thank you. And one very small minor point is I asked ChatGPT, does York have any dedicated LGBTQ venues? And it says yes, and it gives a really glowing endorsement of York's nightlife for LGBT venues. With a pinch of salt on the quality.
That's why I added I said I verified all the ones that pointed up. Yeah. Can't take it as gratis.
Just noting that point. But yeah, thank you for that. Again, I'm minded to go through the one more representative, then have a break because we're approaching 1:30. So that's totally fine. And look, it's been an endurance event today, so fair play to everyone who's still here who doesn't have to be. Thank you, Public Gallery, for still being here. Anyone who has to leave, feel free to leave at any time. I'm conscious the fourth representative, I believe, is a statement from Debbie, and then Bigby has the rest of the 15 minutes. I think that's correct. So if you're happy to proceed, then we'll do that. Yeah, thank you.
Thank you, Graham. From Debbie Saunders, who is a chair of trustees of Generate, a small charity which supports the trans, non-binary and intersex community in York and North Yorkshire. I wrote to you on the 16th of May 2025 to lay out the reasons why Generate are supporting the application by Little J LGBTQIA+ Community Centre for a permanent entertainment licence from the City of York Council. As a charity, we have noted that the City of York Council has reiterated its support for the trans-friendly city status they declared in 2021 and have an aim to be a human rights city. We feel that they are not taking seriously enough the rising tide of hate in the country, with racist, homophobic and transphobic language being openly used on media programmes such as GP News. The government allows the EHRC to produce anti-trans plus guidance that goes well beyond the Supreme Court ruling on the 4 Women Scotland case of the 16th of April, and new guidance for schools appears to be Section 28 2.0. The national picture is played out in York, making the trans, non-binary and intersex community in the city feel profoundly unsafe, and cases of transphobic commentary, hate crime and open disdain for trans plus people are on the rise in the city. For a community that feels that it is being sidelined and driven into the wasteland or confined to home, Little J's has the potential to play a vital role in York's LGBTQI+ community by providing an inclusive space and welcoming space where people of all identities and backgrounds can gather, celebrate, and express themselves through a diverse range of cultural and social events, from live arts and film screenings to theatre, dance, and community socials. Little J will offer programming that not only entertains but empowers our community, fostering visibility, solidarity and well-being among LGBTQI+ individuals in our city. The need for a dedicated licensed space in York has never been clearer, and I have outlined above, hate crimes are on the rise and queer venues are disappearing, so permanent recognition and support from the City Council of York will help ensure that Little J's can continue to provide safe, affirming experiences for all. A permanent entertainment licence will allow the centre to plan and promote events with greater consistency and confidence, enabling it to expand its impact and accessibility. The positive effect on mental health of the community of such a space has the potential to save the NHS significant amounts of money and reduce the rise of suicidal ideation in the community. As the community has worse mental health than the majority community, this is a significant advantage to the public purse. In addition, there are many users of Little J's who are from the wider community of the city, from outside the LGBTQI+ community itself, allowing the mixture of the community with allies from the majority community normalises that each person can be who they are, and that people of any race, gender identity, sexuality, disability, etc., can coexist and all feel safe. When considering the opening hours of this venue, I note that closing at 11 o'clock means that the LGBTQI plus users of the venue will be leaving at a time when the streets are most crowded, and it is most likely that they will come into contact with large groups of alcohol-fueled revelers who pose a risk to LGBTQI plus people. Mixing these two people is likely to be a greater drain on police resources than separating them will be. The community includes a large number of people who enjoy late night activity and who will wish to attend the venue until early in the morning. Allowing such activity will make the venue more viable, but will also mean that the users will leave onto quieter streets where they are less likely to encounter violence. This simple measure, i.e. allowing a later license, offers potential solutions. A, better crowd control. B, reduced incidents and complaints that require police involvement. C, a potential cost saving on the public purse. There are LGBTQI plus venues in nearby cities that are open until 6 a.m. The local community cannot understand why the council expects York LGBTQI residents only venue to close before midnight. Generate would want the premises to be secure and safe for all users. If that means security staff are required, we would support that. But it is unacceptable that an LGBTQIA plus venue should be required to have greater security than other venues. That could be viewed as indirect discrimination on the LGBTQI plus community, which I am sure is not the intention of the City Council or North Yorkshire Police. We ask that the Council considers granting a licence for later opening of this venue, demonstrating York's commitment to diversity and inclusion by supporting a vibrant and secure space for the LGBTQI plus community. Those making the decision should bear in mind the Council's stated trans-friendly city status, the safety of those using the venue, and what a rejection will mean for the community if the venue is unable to continue operating. The community is watching. The community asks for the City of York Council, through its licensing committee, to grant this application and make Little J's the asset to this city that it has the potential to be. Thank you.
Thank you, Bibby. You've got about 9 minutes if you want it.
Little J's is oh, by the way, Generate, they're a charity. I speak only for myself, not for them. Little J's is an essential space that already caters to the needs of the community in ways that no other venue in the city can. There's a demonstrable need for safe and dedicated LGBTQ plus community hub serving York and North Yorkshire, and there is no comparable venue in the York and North Yorkshire region. Little J's is singular in this space and fills a vital and essential role for fostering community, enabling integration and facilitating the sheltering of those at the beginning of their journey to integration. Integration is my mission, and an explicitly queer safe space and community venue is the only way forward. I run a support group for trans and non-binary people through the vehicle of group folk singing. My goal is to reintroduce lost folk, both people and song, to society. This group started in my cramped living room, and considering we now have over 30 members, Little J's was our only option. The moment the owner and I were introduced, it was agreed that my group would be able to use the space free of charge, as the group has no vehicle for profit, and Graham shared our vision for, and mission of community support and integration, and we have had weekly sessions facilitated by Little J's for the many months since. Graham has been stellar in the eyes of the community and my group. His conduct has been kind and supportive. He has repeatedly gone out of his way to provide for us. There have been regular updates to the facilities and infrastructure that my group makes use of, asked for or otherwise, and multiple of us have been shown how to use the equipment. It's worth noting Graham was keen to and has met with community leaders and groups from the queer community, as well as other minority and vulnerable communities, to better understand how to provide for them, both when we asked for and self-initiated. When I've asked members of my group how they feel about Graham, they've reported feeling very supported and welcomed by him, and that he is their first port of call when a space is needed. Little J's being outfitted by toilets that my members can use without questions or confrontations, a stage space, projector, sound system, mixing desk has allowed our members to hone our performance and stagecraft skills, which has enabled members who previously insisted they didn't want to perform to gain the confidence to do so, and for other members who just wanted to share the space and not sing, also to gain the same confidence to do so. We have since performed at a number of other community venues, such as like the Crescent Community Venue and the basement at City Screen. Considering the complicated relationships trans and non-binary people can have with their voice, many of our members have never sung before, and many speak to the confidence that they have gained and the fellowship they have found. The success of our group illustrates how Little J's advances equality of opportunity by enabling marginalised individuals to participate in cultural life on equal terms. These members of our community wouldn't have been able to start this journey and find themselves in this manner without Little J's, as despite my best efforts, the other venues I've approached due to the uncertainty of support for Little J's have either been like unagreeable, unavailable, or unfeasible. They don't know what to do with us due to the uncertainty around the EHRC ruling and temporary guidance. Some venues, including churches and chapels, have initially been receptive, but later said that they were afraid of backlash over trans rights moral panic. None of our theoretical available alternatives are affordable. Little J supports a wealth of other grassroots initiatives, as well as queer businesses, charities, orgs, and performers. It facilitates queer open mic, which is more like a pre-booked cabaret due to how popular it is with local queer talent, many of whom have explicitly stated that they feel too unsafe to perform at the other open mics and venues in town. I personally used to attend as many open mics as possible every week years ago, with as many as 4 in one day. But after multiple days in a row of facing homophobic abuse and attacks on my gender identity while doing so, I stopped. Those experiences were a part of why I locked myself indoors for 4 whole years afterwards. Little J's lets many of us experience life beyond our own 4 walls and serves as a stepping stone to integration. But as some of us are too vulnerable or have experienced too much hate to attempt wider integration, Little J's is one of the very few options we have to enjoy a slice of the city and wider society. Local non-binary writer, comedian and theatre performer Stevie Hook recently performed their acclaimed touring production of Wheel of Nouns at Little J's. Stevie wrote the show to address issues in the trans and non-binary community that they face in an entertaining and yet thought-provoking way. The space was ideally suited to an intimate show and was perfect for finding a supportive and appreciative audience. The show was sold out, and in a survey asking how the event made the audience feel, people said, "I have never felt so wholly safe, supported and entertained at a show before, that it was playful, infinite, empowered, connected. They felt loved and seen, they felt hopeful for a brighter world where people would be able to live themselves without fear of prejudice." And when asked about the venue in the survey, people described Little J's as welcoming, accessible, inclusive, central, and a great queer venue. Such opportunities are rare, as emerging LGBTQ+ artists often struggle to secure venues that are both willing to host their work and accessible to their intended audience and community. Little J's therefore plays a critical role in eliminating barriers to cultural participation. Stevie writes, "I believe this experience wouldn't have been possible without Little J's because a different venue, queer and trans audience members who got so much from the event would have been dissuaded from attending at a different venue. Earlier this year, I put on the Wheel of Nouns at Theatre 41 in York, which is a lovely venue, but not an explicitly queer space. And almost all of the queer and trans people I knew who expressed interest in making it to the show did not come to that show. When I did the show at Little J's, the audience was full of queer and trans people, and the show was sold out. I think this is hugely related to how safe people felt about attending the venue itself. Anecdotally, members of the trans and non-binary community in particular have reported going out less due to the lack of safe spaces and fears about using toilet facilities. The lack of safe, inclusive spaces has resulted in some LGBTQ+ people, especially trans and non-binary individuals, limiting their participation in public and social life. This undermines the equality of opportunity and increases risk of social isolation. Little J's directly addresses this need by providing a safe environment where individuals can participate in cultural, social and wellbeing activities free from harassment or discrimination. We note that positive attitude of the City of York Council in general towards LGBTQ+ community and the benefits which this offers the wider community. This is a key opportunity for the Council to support a very important space with great benefits to the LGBTQ+ community and beyond. I'll finish now on the specificity of why I feel a late night licence is needed and why I feel a 4 AM licence is justified. There has been persistent community need for a queer, safe space venue that operates to this time, and regular remorse expressed at this noticeable gap, with many of our community being forced to travel to Leeds or further for late night queer culture. And again, those aren't at queer safe space venues. They're typically one-off nights. This creates like unnecessary risk and expenditure. people having to travel to those venues and then endure a significant time draft before train services resume so that they can get home after. While other venues in the city have been granted late night licenses, they are not queer safe space venues, and many of us who have tried them have memories of upsetting and unwelcome experiences in them. A 4 a.m. license for Little J's lets visibly queer customers safely disperse in small groups in a manner that reduces risk of unwelcome interaction from neighbouring businesses and provides the opportunity to celebrate our identities on culturally relevant nights for as long as we would like to. Little J's has had great success and experience in doing so on temporary licenses, with the 12-hour-long up to 4 a.m. Pride after party in June. The thrill of a new explicitly queer venue was palpable. It was noticed by all in attendance that anyone who left Little J's to go to other venues who were hosting similar after parties soon returned to Little J's and expressed significant preference in remaining there for the rest of their night. There was also great success in 3 open mic night each event in each of the months after, each of them being licensed until 2 a.m. and extremely well attended by a diverse audience. The open mic has since had to operate until 11 p.m. only, which is greatly unfortunate as there is significant demand for it to go on much later. Both customers and would-be performers have expressed disappointment that these events are now 3 hours shorter, and performers like myself and my group have chosen to step aside to allow other performers to perform, as we have enough talent and interest to book in 6 months worth of performances in advance. Thank you very much. I can say a little bit more or answer the question you've been answering when you ask it, but more examples.
That is time, by the way.
Very well. I'll have to.
It sounded like you're wrapping up, so I was giving you a breather
Thank
in there,
you.
but and I feel like you've already answered my question ahead of time. I was slightly leaning there. You said at the start that you're not representing Generate, but the representative slot is for Generate and was Debbie. So before we go into questions, are you able to represent Debbie and Generate in answering those questions, or would you only be representing yourself?
I won't be representing myself, but I have volunteered. I am familiar.
I appreciate that. Obviously, yeah, a lot of the 1,600 people who've signed a petition would also be happy to talk, etc. I feel like we probably shouldn't go into questions if you aren't Debbie or Generate. I just want to see if anybody else feels that's not appropriate, and I should give that space. But okay, then I think that if that's okay with you, that feels like an appropriate time to break for 10 minutes, and then we'll come back to the fifth representative, and then 5-minute wrap up some questions. Thank you very much. Thank you, everyone. Appreciate your patience. Before we just go into the final representative, I just want to loop back to, Bigby, if that's all right, around the extent to which you're representing Generate, if that's okay.
Yeah, sorry, I just got a bit confused. So I was asked to speak by Generate. I spoke on their behalf by sharing my personal experience.
That's fine. I think with that in mind, I will go through questions. I know that people said they didn't have any anyway, so it might be a fast one, but just to make sure there's been ample opportunity. Any questions from the applicant for Generate? I assume not. No, that's all right, no worries. Police, licensing authority, public protection, Joe and Phil, Wayne and Leo again, Andrew, and Jake. No. Councillors, any questions? No, and as I said, I think you've answered my question I was going to ask, so all good. So we go to the final representative and the final 15-minute representation. Jake Craggs, over to you.
Thank you. So my name is Jake, but I'm also known as my stage name, Bodhi Snatcher. I'm a drag queen, show producer, York resident, and a member of the wider queer community. Thank you for this opportunity to speak today. I'm here today representing not only myself, but my drag family and the community that we have built over the years, performing, curating and directing shows, events, and working in nightlife in and around York. Drag and queer performance art is and can be many things. It can be suited to any and all audiences. However, I want to focus on the importance and need of queer nightlife spaces, because I think that pertains to the licence in particular, which we're talking about. I've been a drag artist in York for 7 years. Within this time, there has been no dedicated, consistent queer nightlife venue, which has meant for myself and performers like me, forging a path into York nightlife and navigating non-queer spaces and trying to build a community where there has not been one for many years. Working with pubs, clubs, universities, theatre and such has had its highs and of course its lows as well. So at the very beginning of all of this, 7 years ago, to get my face out there, I would literally get my face out there. I would walk around and introduce myself to venue managers and ask if they were open to hosting drag events. Just a simple question. I often found that emails, messages on social media, phone calls, I would either be ignored or passed on person to person, and it would often lead to nowhere. So showing up and putting a face to it all seemed to work the best. From this, it became apparent that attitudes and understanding of the queer community varied greatly. In most venues, there would always be a number of staff really excited by the idea, but a majority who either did not care, outright refused, or who came back with harsh words, including transphobic slurs, ignorant statements, and this, of course, was hugely deflating. But I understand how important it is, not only to myself, but the community, to take up space and be visible in a world that doesn't always cater to you. Many venues that initially, I say many venues, there wasn't many venues, venues that initially agreed to host a night or two sadly fizzled out, either because the venues did not understand the need for these events. They did not help to advertise, market, or financially support these events, bearing in mind that most venues have a budget for these things. And in my case, I seem to be an exception to that rule. On the flip side of that, we often ended, I say often, we have ended relationships with venues because of foul behaviour, be that from staff or the public. From door staff misgendering those who present in the opposite gender to the ID. Obviously, in drag, it is a gendered performance, so I look very different to how I look today. The general public invading the space and behaving inappropriately. There is an expectation that in queer safe spaces, things like this do not happen. And if they do happen, they are dealt with in a correct way and not dismissed. However, in my experience, dealing with non-queer venues in York, this has not been the case. In kind of to highlight what it's like outside of York. So it's not just performances that we do in York. We've got 4 regular drag performers who are part of the Family Shambles, but it includes everyone from kind of open night performers, like countless people have performed with us. And every queer venue that's booked me outside of York, the ones that I've been lucky enough to be invited to and perform, it has been a wonderful and memorable experience where instead of being a spectacle to ogle at, I feel valued and appreciated as an artist, which is exactly the standard that I have for my own self-produced shows and why I refuse to settle for less in non-queer venues. Being in drag is a great example of what being visibly queer can mean day to day for people. I'm lucky in the fact that day to day, I generally look like this, but in drag, I'm extremely visibly queer. So it's kind of like having a magnifying glass on all of that. From being questioned about what's between my legs, having my hair pulled, being touched inappropriately, shouted at, or met with aggression. Sadly, it isn't unexpected when you are in drag. And proportionately, it happens more often when in a non-queer space. But it can happen in queer spaces too. The difference is that staff are generally on your side and the behaviour is dealt with, and that you're made to feel safe and secure in that moment. Despite the struggles, I was able to secure a regular monthly event, which started a small buzz around York. The Family Shambles, a group of like-minded drag queens on a mission to create a space for not only themselves, but building a community alongside that. As our nights grew and went to bi-monthly, we were getting booked for private events, student nights, to speak at universities, and even the occasional theatre performance. But along with all that, we garnered a community and created a space where people feel free to express themselves, build relationships, and find chosen family. I've heard stories from those who have supported us along the way. Friendships have been made for life. I know people that have met significant others at part of our shows. Students who are new to York and didn't know there was a queer scene here have been their eyes have been opened and they felt welcomed in the city and they've discovered a home away from home. And local residents and students alike have even started performing alongside us. Without the spaces that we built, this would never have happened. And I see Little J as an opportunity to have something consistent instead of just something that was fleeting. As of now, we have very few queer-led nights like this due to a change in society, a change of venue management, or due to unknown reasons. The only events the Family Shambles now have are either fully self-produced and self-funded, or they're out of town. Cities like Newcastle, Leeds, Hull, Brighton, even Cyprus, anywhere but York seemingly. And I find this difficult to understand because York is my home. York to me is an accepting and welcoming city. It's vibrant and diverse in culture and in its people. When the opportunity arises to support a queer-led venue built to support and accommodate queer people, it should be welcomed and celebrated. In times when our community is demonised, trans people are denied basic rights, drag queens are labelled a danger to children. To protest and speak up for our own rights is seen as criminal. Our community needs a safe space more than ever. Gone are the days of the traditional gay bar, a meeting space for gay men and to meet other gay men. Like there's literally apps for that now. So the bars that haven't moved on with society and including like community spaces, you find they're not surviving. We need spaces that are not policed by societal expectations, bigotry, and ignorance. Where the problems visibly queer people face day to day are minimised, where we can meet those going through life with the same experiences and meeting those who can open doors to new and exciting ones. More than this, community spaces are vital to those looking for support and resources, a hub to connect the wider queer community throughout our city. Through the process, Through this process, facts and figures have been raised by all sides. Statistics are very helpful. However, I can see how these don't show the full story. Behind every number is a person, and you shouldn't ignore their lived experience. So with that said, speaking as Jake here, behind the wig and the lashes, and I'm out for a drink or a dance with my fiance Miles, there is nowhere in York that I feel I'm able to hold his hand in public, nowhere I can dance and celebrate together without the risk of being heckled, looked down upon, or worse. In York, we always have to watch our back. And it's not a case of always being on edge. We do try and relax about it because, you know, fly. But there is nowhere in York, in my home city, where that I feel we are truly able to display our affection for each other. And I know we're not alone in feeling this way. This is a space that is missing for the local York community, and as a safe place for tourists visiting the city who are from all over the world. It would be an opportunity for them to make lifelong memories and feel safe in our city and accepted even when being far from home. And this is something that we've been told over the years of doing our shows. One of my biggest takeaways from doing my own events are the people that I've met along the way. York is said to have over 9 million tourists visit York every year, and some of which I've met personally at these shows. And the one thing that they all say is that they're surprised or even disappointed to see the lack of queer nightlife venues in York. To question the need for such a space is humiliating, just like it is to question the need for pride. It questions my own and many others' lived experiences and it is why we are crying out for a dedicated queer space. It is often used as an argument against us. If this is to be a queer safe space, does that mean it's not safe for others? Why do we need gay pride? This comment alone is ignorant and it highlights a bias against the queer community. As a group with protected characteristics, it is fundamental we have inclusive, safe spaces available to us. The decision today to support and celebrate a queer venue would signal to queer residents that they are deserving of a safe space in the city they call home. For those around the world looking in at York, visiting York, it says you are also welcome and have a space where you can be authentically yourself. For students, it would allow them to call York their home away from home and allow them to connect to the wider queer community here. With all that said, this hearing and decision does not only concern little J, the police and the council. I hope you acknowledge the wider community and in York and beyond, what it would mean to these people and how it can greatly benefit every single party involved. Thank you again for your time and allowing me to speak on this.
Thank you very much. And there's a lot of matter of fact things we're going through straight into 5-minute questions, but appreciate all of the personal stories and experiences that have been shared. And I guess just to reiterate a point from the police earlier, crimes around sexual assault, for example, and the challenges around individual duty of care of venues towards staff and performers and customers, fairly well established in York. They should be, and we need to get better at making sure they're raised in the right ways. It's something we talk about quite a lot in licensing committee and related meetings. But other harassment, including online harassment, the same thing. I think that's something for us to take away is how can we get better at addressing these challenges? And it isn't just LGBTQIA plus people who experience harassment on nights out and things that are clearly criminal, not just inappropriate. But yeah, no, thank you so much for that. Going straight into the 5-minute questions, starting with the applicant, please. Police. Public protection, Sandra again, Joe and Phil, Leo again, Andrew.
None for me.
Big B. Members. Only comment that I've already had is the same question again, which is in terms of, for example, drag performances, and when you've been talking to these different venues about timings of events, I'm guessing that when you were engaging them, they weren't usually, 4 a.m. midweek or whatever. So what's the level of need that you've experienced and seen and the challenges around those late nights?
Thinking about like the licensing and the hours specifically, as I've said, like drag and queer art is and can be anything. But when it pertains to my own drag, it tends to be in the nightlife realm. It tends to involve cabaret shows, having a social drink, whether that's a zero beer behind the bar or a glass of wine. More often is the case that it doesn't tend to be these rowdy, wild nights out because you are there to be entertained. Maybe that is because we're in York and there aren't, you know, giant nightclubs where there's drag queen DJs and things like that. But I don't think that's what Little J's is trying to be. But I think having that flexibility in the hours, like I've been booked at a show and my time slot won't be 2:30 in the morning, and you just do a pop-on appearance and then the next performer and things like that. So I think it's all about flexibility in the night. Like Pride, for example, there were time slots for performers going all through the night so that there was entertainment going on while the crowds were there. So I think it's just important for flexibility, really.
Thank you very much. Finally, we go into, I guess, 5 minutes for each representative to recap any key points. We go with the applicant at the end. So first up is 5 minutes from the police, please.
The comments that people have made today, particularly from the communities from which you've come. Oh, I beg your pardon, sorry. I'm very heartened by that, on the basis that you do come from a community that has and continues to suffer great prejudice, and the fact that you've spoken positively about the police really is positive certainly to me, and I will take that away from this. Regarding this application, it's absolutely the right sort of venue that we should have in York, absolutely. It just happens to be in the wrong place and with the wrong DPS. In respect of the venue itself, the place, that's not insurmountable being in the CIA. We have, from the start, we were significantly engaged with this throughout, and you've heard that. It's something that we have taken seriously. We've asked for conditions, and we would ask, if you were minded to grant the licence, that those conditions are imposed. Looking at the timings, it seems that in respect of this application, there wasn't a lot of thought went into the timings. It was just, we want everything, on the basis that other people have that. York has changed in respect of the CIA, and it is important, I think, to be cognizant not only of what you want, but perhaps what's appropriate in respect of other people's rights, in respect of the licensing objective. So perhaps what we wouldn't object to is during the week up until midnight, and then at a weekend to 1 AM. Because what we've seen is we've been supplied with a list of events that are happening, and it doesn't appear to be a great number of events linked in with wanting really late night drinking 7 days a week. Because on the face of it, regardless of semantics, this is a vertical drinking establishment and can be used as such in the current format. Regardless of what it's referred to, it is a vertical drinking establishment. When I mentioned about safety to children, or safeguarding of children, on page 76 of the report, it does say that, and it's the last point, that if the venue is hired out, then anybody under the age of 18 can remain on that venue until the end. And that was the point I was trying to make, although it appears that throughout the application, and even today, it's the negativity and tension have come not from the support of this applicant or the supporters of this application, but the applicants themselves. You've heard that it's the way in which the applicant has acted himself has seemed to cause and heightened division, particularly when lies have been put in the public forum, and that is why we take issue with the DPS certainly not being a suitable DPS for this particular venue. There's been lots of criticism labelled at people, well, you didn't read a 14-page report. Well, why did you only serve it a couple of days before? why is it that we have got to adhere to absolutely everything and read every report when it's an inherent duty within the policy regarding the CIA that the applicant has to actively engage? And it was a question from, and that hasn't happened. And it was a question from the committee themselves. Has the applicant at any point acknowledged that perhaps they've overstepped the mark? Simple yes or no. And the applicant couldn't even answer that question, Chair. And I think that reflects the nature of the DPS in respect of this matter. So yes, great venue, absolutely. But if it's granted within the CIA, then the conditions need to be tight. The hours we say are wholly unsuitable. But one point that we haven't changed our mind on is the DPS is a wholly unsuitable DPS for this venue. Thank you, Chair.
4 minutes 59, pretty spot on timing there. Thank you very much. 5 minutes next from Public Protection, please.
Hello, Chair. The Environmental Protection are basically concerned about public nuisance being caused and occurring due to a noise breakout through the building envelope. There have been some events run, but they were curtailed often to 11 o'clock. It hasn't been enough to demonstrate that it could run later into the morning without causing a public nuisance. We do need the condition on about the doors and windows being closed, we feel, because if there is music as well being played inside, even if you've got a door shut, when that door opens without an acoustic lobby, then the sound will just fly straight out. So we still would like to have that condition put on. In terms of the noise report, yes, it's arrived way too late for us to review it, so I can't give you a professional advice on whether that's suitable or not suitable. Some reports come in and they're well written, some reports come in and they're not very well written. Sometimes there's oversights on what the applicant has asked for or what the noise consultant has interpreted is required of them. I'm slightly concerned from what was said that it was a short report, because I would expect it to be quite in-depth with lots of information. For example, the low base content being considered. Was it generated by actual noise on the site through a dodecahedron speaker, then that sound being measured going out through the building, or was it just a theoretical assumption based upon some theoretical noise going through a theoretical facade? So there's lots of things we need to look into before I can give you a professional opinion upon that. And I think it's better to get that correct. Obviously, with the application, we could have just request that the application was refused because of this for the regulated entertainment, or have that reduced to 11 o'clock at night indefinitely. But we don't want to do that. We're happy to work with the applicant on this, and the condition about the getting the noise report done and then getting the building sound attenuation done. It protects, it reduces some of the risk of the public nuisance from occurring. Therefore, it protects the applicant. And it protects the residents nearby from potential public nuisance. But it also, if the report comes back and it's fine, great, in a week or two's time, it's signed off and it falls away. If there is an issue, we can work with the applicant to try and ensure that we can get the sound insulation done correctly so that it isn't a problem. And so we're trying to really support them, and also to avoid any expensive condition on the noise limiting device that may be required. It may not be required, and we just don't know at this stage. I think as well, yeah, that's it really. It's about balancing the support for the applicant, the LGBT community, and also the cumulative impact area and the potential for public nuisance to the residents nearby. And so that's why we feel they should be on.
Chair, is there, if there's time, can I add?
You've got 2 minutes.
2 minutes? Oh, okay, I think I'll take 2 minutes. I thought it was less than that. Thank you. Just to add, Chair, that there was some discussion earlier from the applicant that the conditions proposed by Public Protection would not be lawful. If you take that view as a subcommittee, then I think our submission would be that you would have to refuse the application, because Public Protection are your experts on on public nuisance, and at the moment you're in dark as to whether or not what the noise impacts would be. And it would be, my submission, it would be irrational for you to grant an application for regulated entertainment from 11 p.m. when you cannot be satisfied that the statutory licensing objectives have been met.
Thank you. Straight into 5 minutes for the licensing authority, please. Licensing authority, 5 minutes, sorry.
As I think we've previously made clear, just to sum up, that the licensing authority is supportive of an application that meets the community of impact policy and has robust conditions attached to it. The proposal is to operate as a community venue and bar. For a premises license application, a community event venue or a safe space, as I've previously submitted, is not a formal license type. All premises, whether for a space safe for equalities or otherwise, have to show how the venue promotes the licensing objectives. And when applying for a premises license, the concept of providing a safe space or a community venue for equalities groups always has to relate to how the application addresses the 4 statutory licensing objectives. Of course, the PSED is relevant and due regard needs to be had to that, and I've heard my submissions about that previously. But the key consideration for the subcommittee is whether the premises would have a negative impact on the CIA, and ultimately that is the overriding factor for the subcommittee to decide. Thank you.
Thank you very much. Into the representatives. So the first representative is the LGBT Forum. You've got 5 minutes.
Thank you. Yeah, just to, I think, reiterate really what I said earlier, and Phil, who has had to give apologies and head off, just really the importance of having this venue for the community is really paramount in terms of the people we support as a charity. We are really keen that continues. And we would really like to see a safe space in York for the community. So really hopeful that can happen, and anything that the LGBT Forum can do to help facilitate that, we're very happy and ready and willing to help with that. So yes, that's all. Thank you.
Thank you. Second representative is, I guess, Wayne via Leo. Nothing. Third representative, Andrew.
Yeah, thanks. Yeah, I'm not particularly, I'll leave conditions experts to argue about that. I think the only things to emphasize from the point of view of organizing as a group in York is how important having that central focus space is. I say again, like, I'm not entirely clear where else you would put it if not within the middle of town. And we're talking about hypothetical future projects that we might in principle support one day. Well, that doesn't serve anybody at all. The evidence is plain that York struggles with this. So this is the project, and you can support it or not, but this is the chance, and I don't really buy that there are 10 a penny of these to support in the future. So my emphasis would be behind get the conditions right and get this going.
Thank you. And then Bigby.
Yeah, I guess my points are on how essential of a space it is for trans and non-binary identities. The fact that, you know, we're facing toilet-based discrimination out there in the world, and this is a place that is unquestionably and unwaveringly in support of people able to use the facilities that they see fit. And where there is a lack of those kinds of venues in the city, that means that public participation for trans non-binary people doesn't exist within the city. So, you know, there is sanctuary there, there's opportunity, there's the ability to take part. Like I say, outside of the context of your own 4 walls at home, you know, the fact that, you know, the fact that we've got it and that it's central means no unnecessary risk and expenditure around travel to, again, venues that, like in Leeds, may not, again, be explicitly queer venues, safe space venues, things like that. And I'd like to again speak to the necessity of it being a late night license due to the kinds of things it facilitates in terms of drag acts, in terms of sort of like DJs and things like that. This nightlife economy can't be brought earlier into the day. It doesn't work. There's no demand for it earlier in the day. A lot of this kind of thing, you know, theoretically we could put it on, but that custom doesn't exist. The nighttime economy exists within the nighttime for a reason. I think those are my crucial points. Thank you.
Thank you very much. Jake.
I suppose it's kind of echoing what everyone else has said, but this is like the only opportunity that I've had to speak on anything like this while living in York, and the only opportunity to jump on the bandwagon, so to speak, and get a community space like this off the ground. So I think now is the only point in time I can see parties like the police, licensing, working together. And I think it's forging a path where this is the moment, because we're probably not going to get this again. So I guess that's all I can say on that, really.
Thank you very much. And a hard 5 minutes from the applicant as well.
Well, it is going to be a hard 5 minutes, sir, because it's very disappointing. And so if I need more time to make this important case, I crave your indulgence that you won't silence me as the responsible authorities are attempting to silence so many members of the community. Firstly, you and your colleagues must grapple conscientiously and with an open mind with your public sector equality duty, which means having due regard to the need to eliminate unlawful discrimination, harassment and victimisation, to advance the equality of opportunity and to foster good relations between people of shared characteristics. Please do not follow the example being set by the legal representatives from your responsible authorities. They are encouraging you to take a path of error and unlawfulness, and one which will in fact cause you to be discriminatory, cause you to set back the equality of opportunity and to in fact foster poor relations. It's really concerning that the senior solicitor of the council, on behalf of your licensing authority, tells you, in the context of all we've heard today, in the context of the personal direct evidence of so many residents and activists in your city, that she continues on behalf of the licensing authority to say wrongly that cumulative impact is the overriding factor. What she is saying to you is those few paragraphs that make Chapter 9 of your entire statement of licensing policy are more important than everything else. That's wrong, isn't it? Because if that was the case, let's throw the statement of licensing policy out the window. When your statement of licensing policy says you have a vision, and that vision includes, amongst other things, a safe city centre which is welcoming and accessible to all, it's in the CIZ, forget it, she says. That's really wrong. When you have a policy that says you must grapple with the public sector equality duty, forget it, she says. It's in the city centre. That doesn't apply. She is wrong. When you have a policy that says diversity and diversification of offering is a good thing, paragraph 6.4, that it attracts visitors, that it improves the city centre, and she tells you, forget it, she is wrong. So when it all hinges on a cumulative impact policy, it's just unhelpful. When you set it up as this idol, as this fetish, and there's nothing else, what she's effectively trying to do is to have you take a blinkered approach. When, on behalf of the licensing authority, they say, well, there's not enough robust conditions, what have we been talking about? You're the experts. Is there anything else you can suggest? I've suggested things. The police have suggested things. What have the local authority done? As the licensing authority, they've suggested nothing. They've closed their mind. CIA, CIA, CIA. Come on, get imaginative. Apply your policy. Public protection are careful. Apparently, you're in the dark. You have no evidence. Well, we've all been able to read all of the evidence. First and foremost, the police officers quite clearly said, we don't have any problems with antisocial behaviour, which is a part of public nuisance. There's a report prepared for you for us to read for this morning. And, you know, we're all busy people, but we all have homework to do. And we either come to committee prepared or we come to committee with a lawyer to say, I've not done my homework, I've not done my homework. It's pretty upsetting, particularly when the conclusions, I need more than a minute, when the conclusions of the report, well, I'm going to keep talking, when the conclusions of the report clearly state that there are no adverse impacts. And then finally, when the police say, we believe in equality, but I tell you what, shut the gays down at midnight and 1 a.m. What's that saying? Shut the only queer venue that proposes to open before everyone else. Send them home, send them packing, and early to bed. They've also not grappled with their public sector equality duty. What in fact you have is a sound application by a very pugnacious and, you know, you don't come across easily, but an activist for his community saying, give us this chance, who's agreed to all the demands and paid for tests, assessments and so on, which some of us have read, all of which say we will not have an adverse impact, we will operate well, we will promote the licensing objectives, and I'll finish on this. And above and beyond this, this venue will directly and actively promote the elimination of unlawful discrimination, harassment and victimization. It will advance equality of opportunity and it will aim to foster good relations.
Thank you.
That is exceptional.
Over 5 minutes.
And on that basis alone ought to be granted. Thank you very much.
Thank you. We move now into questions from members as the final section of the public part before we go into private session. Hopefully everyone feels that we've been listening, everyone feels that we've heard what has been said on all parties, and we now have a few clarifications, I'm sure, and some questions before we go into private session. I don't know who wants to start.
I think the things on conditions that I'm thinking about, I have actually had a bit of clarity on, so I think I'm okay.
Just for the police on vertical drinking, you talk about putting tables down to restrict the numbers of, what sort of balance would you think reasonable in terms of between vertical? I don't think we can have no vertical drinking, but what sort of proportion out of 120 would be seated and standing?
Yeah, these can be lengthy discussions that we would usually have with applicants quite early on, because it's important for us, as we're not fire experts, to understand what the safe capacity is before we start throwing numbers in that could then potentially affect that safe capacity. So once we have that kind of safe capacity and we're looking at that safety aspect, we would then look at a reasonable number, just as a point of clarity. And again, talking on that diversity element, as the licensing officer for York and dealing with these applications regularly, a regular application that came in just for vertical drinking with no offer of seating, the first thing I would be asking for is food-led and seating. So the absence of me asking for in this application and us asking for that in this application is down to the fact that we are trying to support this type of an application. But regularly we would look at sort of at least 2/3 of the premises being covered by some kind of seating, if you are asking in regards to a normal application. Yeah.
Right. The applicant, you had that fire report. When did you ask for that and when did you get it?
The draft I have is.
Did you say fire?
Yeah, you said you had a fire safety.
Fire safety, yeah. I think the draft I had
those numbers.
We've never been asked for the fire safety.
No, you asked the fire, someone to give you.
I think the version I've been given is February 2025.
So if that's since February 25 and you haven't shared it.
We've never been asked to share it.
No. And your attempt to prove why you should fit and proper, you didn't think it was worth saying.
Well, fit and proper isn't the legal test, sir.
Well, what are you gonna? I'm not
Well,
legal.
no, not well, whatever. Either you should follow the correct legal principles or recuse yourself.
I'm not a lawyer. I'm not using fancy language for you, though. Sorry. So February, and you kept it. That's fine. Yes, just going back to what I asked earlier, which is sort of prompted. You've heard a lot of people say nice things, but the applicant is still saying that his attitude towards the police throughout this, he shows no regret.
No, none. Do you want to answer this? No, none.
Okay.
He has agreed to all the police conditions. He has an open mind. He engages experts, but he is proud of his activism. And I've explained where that might come from. But the events that he's operated through the temporary events notice or outside of the temporary events notices go well. Certainly the advice I've given him, and I'll say it again in public forum, is I appreciate particularly with the sergeant and her colleague. They've spoken very fairly and I think very well. And I have no direct criticism of the two of them at all. I would encourage him to engage with them, and they are certainly the fairest and very well informed police licensing officers. But no, Mr. Dyke does not take a step back from his activism.
I've got a few. There's a kind of, I appreciate it wasn't a kind of critical point or a definite, but the idea of having some form of seating numbers to kind of support the difference against vertical drinking. It's also useful for accessibility as well in terms of having some seating available. But I was just wondering if you had any suggestions for a potential condition that would help to encourage the distinction from vertical drinking.
So I think this. I'm grateful for what the police have to say about vertical drinking. If this were a vertical drinking bar, then I would understand it would be opposed, and I can understand why. But the point is, I think it's your the lawyer for public protection and licensing says, this is no formal license type, or there's only one type of license, and that's a premises license. The way in which a premises license is restricted and regulated is by its use. So the most important condition in this suite is that the premises will operate as an LGBTQIA+ events, venue and bar. That's the suggestion by the police. So in much the same way that a premises can operate as a restaurant, it can operate as a cinema and so on, or a theatre, that restricts its use. So what we have here is whether or not it will operate a bar, whether people can stand. Yes, at times it will. I have to admit that. So if there's a pride event or a party or a nightclub, then it will be predominantly it will be vertical. However, on cabaret nights, live mic nights, and so on, there will be tables there, and there are tables there, and they are used. If you go into the venue, you will see them all stacked on the left-hand side. When the tables are used, the capacity is about 70 to 80 persons. And because of chairs and fire safety.
And understand that point, you've already kind of agreed to the conditionability of that.
So I'm trying to think.
Drinking generally, because it is a license that would allow vertical drinking.
It is a license that would allow vertical drinking, but it also allows vertical dancing and entertainment and so on. So it's certainly within your decision-making process to say there shall be no vertical drinking, and the operator can take a view on that.
But there's no proposal conditions from your side in modifying what's in that particular space, but for example, seating numbers or.
No, there isn't. I'd welcome any suggestions that anyone might have as part of the discussion, but I can't think of to say no vertical drinking will mean that you can't use it as a bar or a nightclub space as might be needed from time to time.
Yeah, I understand. And I guess the point I'm making is around that cumulative impact area where vertical drinking is the primary concern. It's been the primary concern of multiple parties, and anything that we can do that conditions it to appease people, if we can find common ground where everybody's happy, that's obviously ideal. But yes, Mark.
Just on that, you said earlier on that in part of the conditions, you happily put the monthly sort of rolling program. Yes. Could that be built into that in some way? Do you think that?
So,
Say if you put, if cabaret's on, you're not going to have you're going to have people seating, I guess, watching the entertainment if you've got, and folk artists, there'll be, so you can say no vertical drinking required for the folk. But if you, as you say, you've got a disco on, it's obvious it's no seating, we're having a dance and a drink.
So I've thought about that, and I've thought to myself, okay, so cabaret ends at 12 o'clock, or folk music ends at 9, 10, 11 o'clock. With respect to the folk music community, I'm not sure how popular these events might be or how economically viable. So the question I ask myself then is, I'm sorry, there's clearly folk music fans. I told you I'm really good at upsetting people. So the question I've asked myself in that circumstance is, okay, well, the folk music finishes at 10, drag cabaret finishes at 12. Can the venue operate as a bar, as a vertical drinking bar in the CIA, which I acknowledge, because that's how it needs to finance itself, which is what we've been talking about. So I struggle with the condition, but it seems to me that part of the answer is in condition 1 and the risk assessment. And I've been working along the following suggestions, something along the lines of the applicant shall provide and maintain an events diary, which shall be provided to the police and the licensing authority at least 1 month in advance. As a minimum, the events shall include an indication of the licensable activities, the hours of operation, the hours of bar use, and other relevant matters. Now, what that means is that if you've got a diary where it says bar from 10 till 4, 10 to 4, 10 to 4, every weekend, month in, month out, that is not a premises that is operating as an LGBTQ plus events space. So I think that the answer is in 2 parts. It's condition 1 of the police coupled with the events diary, because if you see that they're doing nothing but keeping the space open until the longest it's allowed, then it's just operating the bar. It's much the same way as if you have a restaurant license that says alcohol must be ancillary to food, and you go in on an inspection and all they serve is peanuts and a bowl of olives, then you know that that's not a real restaurant. And I think it's my colleague Sandra asked, well, what does it mean to be a queer space? Well, it means it's by queer people for queer people. And so just looking at that timetable of events will demonstrate that they are using it in that way. And this, I think, is what answers the fear of it just turning into yet another vertical drinking bar in the CIA, albeit for the gay community, which I think is what, from a narrow policing perspective, and I don't criticize that, what we're trying to avoid. And I don't want to say on behalf of Graham that it won't be used as a bar, because it will have to be at times. But what's more important is that it is more used as a proper venue. And the proof of that, as this community venue, will be in this condition that I'm suggesting, which can be properly tabulated to demonstrate what time the activities end and how late will the bar run, for example. That's the best that I've come up with, and I'm very happy to be challenged by colleagues who have any better ideas.
Thanks. I have slightly more assurance on the fact that there is a condition specifically around that than some of the words we've heard today, but that doesn't guarantee that there is no ability to use it as a vertical drinking establishment. No. Hence, trying to get some clarity on that piece. Doors and windows. Obviously, there's a specific sticking point on this. I don't want to spend any time talking about what is legally allowed or not. I think we can make our judgment on that. But the principle of sound can escape through open holes in the venue. If you have a door open and another door open, then the sound can come out. I think is a reasonable point in general around noise protection. Is there anything you would suggest that's different to the condition that's been offered by?
So in terms of page 98, condition 2, the rear door, except for ingress or access and windows, shall remain closed when regulated entertainment is taking place from 10 p.m, which is already part of the condition. I can't offer the front door to remain closed because that will mean that we are either undermining the fire risk assessment or causing a hazard on the public highway. So the very front door, I can't do that. What I can also suggest is that the secondary door, which on the plan at page 77 is where the green arrow is, that internal door could be kept closed. So the rear and internal door. And that would be the distinction, because then you, in effect, have a partial acoustic lobby, albeit, as public protection point out, when that internal door opens and closes, there will be access to the outside area. But the noise report that you have, following the methodology approved with the council, is that the noise level late at night will be masked by ambient noise levels in any event. So there'll be no impact.
Yeah, I understand the report, and I let's not get into it. But from both the police and the applicant, a little bit rich to say that 2 days isn't enough to respect, to provide a full response to the side. We are where we are with that. We haven't got a full vetting from public protection around the details of that. But to what extent do you think, obviously we've still got the conditions that you would like in terms of being able to validate the impact of that noise, but that internal door, external door, I'm sure the external door could be modified to be closed somehow at great expense. But to avoid that, is there anything with that internal door situation at the front? Conscious it's basically opposite a hotel as well in terms of...
Yeah, I'm just not sure about that. I mean, I think I'm glad that they've got the windows being closed and the back door being closed. In relation to that middle door, I mean, surely on other towards the front, surely on other premises, the doors can close, but then they can open to let ingress and egress. Say again. Yeah, you just need a push board to open it and let it close back on itself again. I can't see where the issue would be from our condition.
I think
Which door are you talking about there?
Is that the front one here? Going onto the pavement, that one could be open, but this intermediary door.
That one can be closed.
That
one closed.
Yeah, and in that case, that's what we kind of mean. So it's that door. It's the front door, the intermediary door at the front. It is the back door to be closed. And this one here.
That's not our door. That's the fire door for the neighbouring club.
Fire door, yeah.
So what I think you've said, which is really helpful, because I think we now agree, is the front door can stay open, yeah? The one that goes out into the street.
Yeah.
That's always been our concern.
Right, I get you.
But
Yeah,
the
we
one
want to
on
use this as an acoustic
that
lobby.
that does close.
Yeah.
So those two doors being closed, except when people are using them as doors, would be appropriate from your perspective, within the context of the other.
Bear me a second, because then when you open that door, the noise is going to come out, and then therefore it could come out again. So really, you need both doors to be closable. Yeah, they need to be closed, or have an acoustic lobby there. Yeah, because once you go through here, it'd be the same situation. But the main need from the actual acoustics of the building, you may need an acoustic lobby here, another door here, because every time the door opens at the back, even for ingress and egress, noise will burst out at that point.
I understand kind of an airlock on both ends where you've got two doors would be the ideal way of making sure that when someone opens the door, there isn't sound coming out for that temporary period of time.
Exactly, and that would be the same here. So is it a historic door, the front door?
No.
Is it a historic door? So
it's replaced, not by us.
The very front door, it was opened outwards because Jalou did that. Because they had to, for their fire risk assessment for their fire escapes from Jalou. So the door that you said can the other door, that's Jalou's fire escape, and then they go out that final exit door. But obviously you can understand if that is closed, when anyone goes in and out, it's
opening outwards.
Yeah.
Could you change that door so the mechanism so that it comes inwards?
No, because Jalou's fire policy means that it has to
open that way.
Yeah.
So
I think we understand where everyone's at, but we can take that away.
As far as we can go is that the rear door and the internal door Little J.
I understand where
that's
we're
as far
at.
as we can
go. That's totally understandable. I just want to make sure we know where the position is and what can move on that. Yeah, appreciate that. The point around the venue hiring out under 18-year-olds can be any time, not just stopping at 10 p.m. That is, I guess, relatively unusual. I know the logic would be if someone's having a birthday party and they've got supervised there, but theoretically speaking, they could be other people who hire it out. There's an element of risk there around that child protection piece. Are you any thoughts about any other ways of making that more robust around?
suggested is the premises may run family-run friendly events, and children under the age of 18 may be permitted if they are accompanied by an adult up to 2,200 hours. No children under the age of 18 will be permitted beyond 2,200 hours. So effectively,
those are fine. It's the final paragraph in that section that's the question.
Well, I think we could just put subject to supervision from appropriate adults. So if you have a wedding party and people bring their kids, presumably they would be under supervision. It could be
if you've had a positive event where everything is done 100%, I guess the question is, if the venue is hired out, what's the level of assurance given to the fact that the people hiring it out, which might not be a wedding, are definitely going to be able to supervise children at 2 a.m. or whatever?
It would be part of the terms of hire, wouldn't it? I mean, normally terms of hire include bar staff, noise levels, you know, how you clean up, looking after, and so an appropriate risk assessment to deal with children yeah, children to be supervised by adults or responsible adults, a normal part of any terms of hire.
Yes, but it's not conditioned on the license that you have adequate terms of hire, I suppose.
In the operating schedule, and we were requested by the licensing authority to add adult supervision, which we agreed to.
I'm quite happy to add adult supervision.
So I'm only happy
subject
because
to risk assessment if there's that level of concern, of course. I just yeah.
No, that's understood. Thank you. I'm just sounding out the things that have been raised throughout. A question for, I don't know if it's police or licensing, but the door staff, 2 door staff piece. There's a question around how it's treated compared to other venues across the city centre. I'm aware that there are lots of venues that have 2 door staff as an obligation. I don't know about Pop World and the places in this vicinity, but could you kind of give an element of confidence in when, you know, 10 p.m. versus 7 p.m. days of the week, different types of events? What's the norm?
So I think obviously York has a very big race season, as you're aware, brings in a lot of visitors to the city. We have a lot of premises that actually have their door staff on earlier because of the race days. And if that's something that you're minded to look at, you may wish to look at a specific condition around race days specifically in relation to that. Obviously, each venue's door staff is considered in its own merits, depending on the style of what the venue is. And there's been a lot of discussion here today in relation to obviously the events, and us. We weren't obviously offered that beforehand. So we've based our conditions around what was proposed to us in the original operating schedule. What I would say is I would ask the committee to be mindful of the race season in York, and also again on that Friday, Saturday evening where we do have the calls for service within the CIA area itself. That is why we have asked for the door staff condition from that 1900 hours onwards. And that's something that's why we've based that on the information provided from the applicant at this time. When you're talking about other venues nearby, they've all got very different door staff conditions dependent on the style of venue.
Can I just come in? Can I just come in following on from that, from a policing perspective, and just say that any new applications that come in, it would be highly unusual for us to recommend door staff from 10 p.m. That would be considered really very late. We would always look at any new applications coming into that cumulative impact area at door staff coming on, you know, depending on the style of venue at an earlier time. Here it's suggested 7. Some venues that has been suggested from 5 p.m. and such. So it's 10 p.m. would be considered quite late.
Thank you. I'll come to you in a second, but can I just confirm that the police's perspective at this point in time is that, including days when they're not selling alcohol, there should be 2 door staff from 7 p.m. onwards?
Well, I think the condition of hours is for that licensable activity. So if licensable activity, of course, if there is no licensable activity taking place, you know, if they were having a crafting event or different things that we've talked about here today, and there's no licensable activities, then they've been under no obligation to follow those conditions. But if licensable activities are taking place, then our position would remain the same for the condition that we've offered.
Thank you. Leo, I appreciate your comment.
Just say, obviously, the concern race days, we've agreed for SIA and race days as well. That's one of that.
And does that include when there's no alcohol sales on a race day? If you were having a 1 a.m. cabaret that's teetotal?
What the police condition are asking for is licensable activities, so that would be regulated entertainment and alcohol. We've suggested to you just alcohol. I think it would kind of a rare event that there would be regulated entertainment without alcohol, but there might be dry nights. And if there are those dry nights and there are no alcohol sales, then we would request that, which is the small venue, and it's just disproportionate to have 2 SIAs, though I accept there's the safety around what goes on outside as well as inside, but we've got cameras and a manager and so on, which deal with those other factors. So that's a value judgment for you.
And obviously we're happy to look at, I guess I'm specifically just thinking, if there's Saturday nights or race days in particular where you are doing a late night event that isn't, alcohol based, but it is a licensable activity, or otherwise that might be a situation where not because of the alcohol of the people that are present, but in general, there is an expectation across a lot of the city, including outside the cumulative impact area actually as well, that there is some sort of change in the way they operate. There's a bigger conversation we had about how much York tolerates on that.
And I think that's really absolutely, Chair. That is the purpose of us using the wording licensable activity rather than sale of alcohol, because it's understanding that wider impact in the city, not just this one particular venue. So that's why we've looked at that.
And I don't criticise the police for doing that. I've put forward the alternative. I've put the alternative only based on the way we propose to operate, but I completely understand the rationale of the police and accept the force of it.
That's fine. I was just testing the appetite on conditions like that. That's. Have you guys got more questions? I've got a few more.
Yeah, just on clarification of the door at the back.
Sorry.
So the door at the back is the only door between the main entrance and the smoking area?
So at the back, yes. So if you look at the plan on page 77.
Yeah. So if someone's going for a fag, they're going to open the door to let all the sound out. There's no secondary door.
No, there's no secondary door.
So when they did the.
We have agreed for the lobby. We have agreed
at the back.
We did agree a secondary door. We were happy to put it.
At the back.
We discussed it. Nothing been formally agreed. We did discuss it. We did discuss it. It's good that he's saying we're going to do that, because that's really excellent. You need to have like an acoustic lobby, some description towards the back to prevent the noise from coming out. Again, we'll have to look at the noise report for that, see whether that's included in there as well, and look at the premises to make sure that it's acoustically sound, which is why we need to spend a bit more time on it. But yeah, if there's an acoustic lobby between the main bar area where people are allowed to go to and that back door, then that would act as an acoustic lobby. And I think it's achievable. I remember being at the site and the bar is separated off. There's a door there, so it is achievable.
If you look at where the pink dot, just opposite that sort of I was talking about the colours that was very calm.
It's Jason Street. No, you're on the wrong page. I know what page number is it on the real page?
77.
So that is not next to the entrance of the toilet.
And just to confirm, you're happy for that to be a condition of the licence to have that in place?
Yeah, it was always our intention from Michael's first meeting that that would be the situation, and it allows for, like you say, and like an airlock, so you open one door and one door shut behind you before you open the next.
I don't think it was on the list of conditions that had been written down. Okay, a few questions from me. I mean, I do want to dig slightly back into this broader piece around everyone not backing down from things that have happened. I guess my question for the police first is, do you think it's definitely appropriate to question the safety for non-LGBTQIA people at the premises, the question about the impact on other people's rights, or would it be better to perhaps ask that as a question around the extent to which other people are welcome at the facility? It feels like that was perhaps more inflammatory than was intended. I don't know if you've got any comments to make on that.
Chair, just in relation, I think we've pointed out today that we recognise there is a need for this style of venue within the city, but we're very much mindful as well that we don't want the venue also to be subject to, I suppose, further. We've seen the comments in the pack about comments that have been made about the venue and why people are then saying, well, why should that venue be given? We appreciate that that venue is needed within the city for that community. What we're trying to do here is to say that actually if other people wanted to attend that venue as well, would they be welcome? So is it a totally inclusive venue as well? Because that's us educating we want to educate our other communities that we engage with, and particularly in relation to our other licensees. There's been some comments today about how other venues have not managed that appropriately. That's not something we condone from a police licensing side either. So I think I just wanted to, and certainly if it's come across in an inflammatory way, that was not the way it was meant. It was meant that if the venue has, and it's your intention to grant the license, that it is a totally inclusive venue. And someone mentioned it, I can't remember which one of the representatives, but that we grow from that as part. So I think that was in relation to that.
I appreciate that climb down, because I think
Yeah,
it
certainly,
could have been asked as a question
Yes.
of, could you please explain the extent to which people who aren't part of the LGBTQIA community, allies or otherwise, would be welcome at the venue? What kind of openness is there? It came across perhaps a little bit more heated than intended. There's a little bit of lawyers saying things as points that aren't questions and vice versa.
Yeah.
Yeah, just in respect of that, Chair, it was an attempt, because clearly we've heard from the experiences that people have had, some really personal comments that, and it's incredibly difficult. What we want to make sure is if this venue is granted a license, that there's no way that these people who seek to criticise for whatever reason have any in at all. So that if there is, well, why are they getting that license when we asked for one last week and we didn't get it, or ours was refused? And so it might seem a bit like splitting semantics, but it needs to be clear to show that it then undermines any argument that there could possibly be.
Fully understand. And you only got 5 minutes to say a thing. Wording isn't always perfect. I think everyone in the room can appreciate that. I guess I'm making the point around some of the ways in which things have been said. Obviously, I mean, I guess there's no way to test if someone's LGBTQIA plus in a reasonable way anyway, but just for validation, it is an open space for anyone.
So obviously it is open. We welcome people, and you've heard evidence for that. And each case is decided on its own merits. So if heteronormative venues are upset, if you choose to grant this, then obviously it's would only be granted if it's a genuine exception to policy. So they shouldn't be upset at all.
Yeah, I've got no concerns over our decision, whatever that may be. We'll revert back to the point we've made a few times, which is my opinion reading through all of the papers is that there were times here where people were just doing their job and doing it effectively. And the consequence was that they received quite a lot of negative comments about them that didn't feel appropriate, and that there were some things that were said in public that were perhaps slightly misrepresenting the specific way in which things happened, without getting into any of the details, particularly of things that are in the private papers. I just want to validate if anybody wants to make any comments around ways in which perhaps that wasn't the best way of doing things on the applicant's side before we move away from this topic.
I'll repeat my advice to my client that working in partnership, having an open mind is really vital to moving licensing forward. Both police officers have been super helpful. So has public protection and the licensing officer. I know some of the officers. As I say, I appreciate the language of protest and campaigning might not have sat well, but we don't apologise.
Okay, I mean,
and I welcome
I'm not going to try and bypass the barrister, but that is a very legalese way of saying that things were said, and we don't want to take any culpability from it. And whatever happens, the police and the representatives will have to work with each other regardless of anything else. So yes, of course, we assume that people will work together. I'm just trying to get to a position where we understand the level at which people do accept responsibility for their decisions, words, and actions. But I will take that as that's the only comment we're getting on it. My last piece is really around those hours of operation and the different types of licensable activity, the fact that it is a real blanket of here's everything that we can apply for, and it's all of the hours available to us. So 7:30 till 3:30 a.m. on a Monday, when Ziggy's and Pop World close at 3:30 or 3 on a Friday, Saturday night. These are quite extensive hours. It is interesting and noteworthy that we haven't had any complaints from the police or from licensing about those hours specifically. But that feels like an area of disquiet, in an area where the other venues locally, including late night nightclubs, don't have those hours, but they are requested here. Indoor plays until 4 a.m., indoor films till 4 a.m., indoor sporting events till 4 a.m., each of those other categories as well. Obviously, we put that question to representatives at that point in time, but are there any of these areas where it feels appropriate that there's some wiggle room from your perspectives as applicants, that maybe it isn't necessary to apply for hours that are even more extended than any other venue in the area?
I think when you mention films and things, it's because we do want to have film showings, and they may form part of some of the entertainment that we have, during the time. The only thing I would say is the late night economy in York, in the cumulative impact area, is licensed until 4 a.m. and is open till 4:30.
So I think the answer to that is no. I think what has been the keenness is to provide a flexible application, but I think it's and I think it is very generous actually that the responsible authorities haven't focused on hours, which is something to take into account. But clearly, you as a licensing committee are an experienced committee, and it is a relevant factor for you to take into account. But I think far better said than myself was just the value of flexibility to the different community spaces that might be able to use it. So being able to say, we want to have a cabaret followed by a rugby victory. I hope you win matches. I was being optimistic. But follow up with a sort of rugby viewing, and then the bar staying open late. I mean, that's the idea of that flexibility, which I appreciate will be alarming from a cumulative impact assessment point of view. But when you're thinking about a venue such as this in this location for this particular community, that flexibility is somewhat paramount. It may well be that just practicalities and economics mean that, I mean, I don't mind saying, I asked Graham this, who's going to want to drink at sort of, 2:30, 3 a.m. on a Tuesday? And when you think about the cost of lights, bar, SIA, music license, and so on, I suspect economics might have a far stronger impact on the actual hours operated than all the very sort of useful representations today. And it may well be that flexibility is exercised very rarely. Which I suspect might be closer to the reality.
Yeah, obviously temporary event notice is still possible, and there could be a scenario where the World Cup is in Americas next year. Two boyfriends who love football might want to go and watch Mexico time matches at 3 a.m. or whatever it might be. I don't know what the timings of the matches are, but there are scenarios where that could be the case, but that can be managed outside of, it could be a 5 a.m. match, which wouldn't be licensed. Last one from me is for the police, and then for licensing authority, is the fire safety piece. We've kind of heard it isn't in the records. There was a reference made to potential of lodging within 21 days, or whether it might need to be approved by the police or fire or something else or whatever. I just want to double check what your perspective is on that kind of fire safety piece.
Just in relation to the fire safety, so as police officers, we're not experts in relation to that. I have endeavoured myself to liaise with the fire officer from North Yorkshire Fire and Rescue, which I think the applicant has also attempted to engage with. Unfortunately, he has been on a period of annual leave, and my understanding is that an appointment has been arranged for the 20th of November at the premises with North Yorkshire Fire and Rescue officers. So until I actually get the details of that, and in the absence of seeing a fire risk assessment to date, it wouldn't be appropriate for us as the police to comment on that capacity aspect, because obviously the fire service are doing their inspection on the 20th of November, and I'm sure at that point they'll link in with the applicant regarding his fire risk assessment. My concern that just from a responsible authority point of view was, as we would do with any venue, if we go to a venue and we feel that there are any concerns around public safety, we highlight that to the relevant responsible authority to look at, because that's their experience.
Same question on licensing. Is there a condition that we should be putting or thinking about in place for that one?
So yeah, fire is covered by other legislation, so it's not generally submitted as part of a licensing application. We consult the fire service. I too have spoken to the fire service because it's an unusual venue, and purely because we're not the experts, we refer to the experts. It's unusual as in it shares a fire escape with a busy venue next door, and also the issue that we've talked about, the gate. So we have sought the advice from the experts. As yet, we've not got that advice. So yeah, it's an unusual situation, but we wouldn't normally ask for a fire risk assessment to be submitted, because it's the applicant's, an operator's duty to do one, but it's completely separate from licensing. So
Totally fair. And I suspect that if it had said 120 capacity as evidenced in our fire report, we wouldn't have needed the full report anyway. I think it was that specific sticking point that we'd had. Any final questions from our side of the table? No. Thank you everyone for your time. I appreciate we've been here for over 5 hours. That is a long time. So thank you for bearing with all of that. We're going to close the public hearing at this point and reconvene in private for deliberations. If people want to wait, we will come back and tell them if a decision has been made today or if it'll be another day. And if so, what the decision is, if it has been made today. As I said before, the decision might take a while or it might not be decided right now, but regardless of that, a decision will be notified in writing to all parties within 5 working days. You are, of course, welcome to leave if you don't want to stick around. Thank you, everyone, for a huge amount of time and care put into this. Thanks.